Good morning, everybody. Happy Super Friday. Welcome to TCF Live. My name is Dan Soul. I will guide you on our 3-hour journey through Courtlandia this morning, starting in St. Joseph County, Michigan. This is Judge Middleton.
A little bit early, and there are a lot of pre-trials. We've got several people in custody, and custody here is not ideal. And we also will need an interpreter. So today's song, Shared Moment of Humanity, is Wake Up, Maggie. I think I got something to say to you. It's late September and I really should be back at school. I know I keep you amused, but I feel I'm being used. Oh, Maggie, I couldn't have tried anymore. That song probably has the best mandolin part of any popular song in history. Anyway, you all know it. Listen to it and we'll have a little shared moment of humanity today. Good morning to Mr. George. His many fans. All right, thank you for that indulgence. I do just what I call a little shared moment of humanity every day. And then if they know the song, they can think about it. If they don't know it, they can look it up. Maybe we'll all listen to it on the same day. Anyway, the matter we're going to address right now was set on short notice. It's People versus Bill Travis Eugene Black. That's you, sir? Yes. Here with your lawyer, Mr. Timothy George. Mr. Black, you were charged with assault and battery for an incident that happened way a year ago, almost, August of 25. You got arrested on that charge in October, pled not guilty. I'm not sure what took so long. The matter got adjourned a couple of times. Anyway, it was set for jury trial for next Wednesday on a charge of assault and battery. Assault and battery is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. The prosecutor has agreed to dismiss that charge for a plea to disturbing the peace. Disturbing the peace is an old-fashioned misdemeanor, meaning it's punishable by up to 90 days in jail and a fine of up to $500. Are you going to plead to that charge?
Yes.
All right. The file number here, if I didn't say it, is 251961 SM. All right. Do you understand that if you do plead to this charge, you're going to give up the rights that are here on your advice of rights, including the right to have a trial and have Mr. George with you at the trial? Do you understand?
Yes, sir.
Mr. George said to me, I'm not sure this case was worth bringing in 30 jurors. That was an incident that happened out on the street. I'm glad we were able to resolve this. I don't know if they put this in my queue or not. They did not. The lawyers are back here in the jury room. The prosecutor is not here yet, but the lawyers and the magistrates talking about the cases. We have about 45 cases with 33 defendants, plus a couple extras. So we're going to be busy this morning. This is the day when I earn my $12 an hour. All right, Mr. Black, you'd had some sort of disagreement with the Mr. Mishka. Did you and he encounter each other in Constantine on September 8th?
Yes.
What were you guys on about? What was this about?
I saw him. Go ahead. I saw him bike past, and we had issues prior, like probably like a year, maybe a couple years before. Him and his friend had jumped me or whatever, and so I wanted to see if we still had issues because I don't like to like worry about things, so I just wanted to see if we were okay, and he said that we were fine, but I noticed that he had a knife in his pocket, and he was reaching in his pocket, and so I got scared, and so
So it turned into a scuffle there on the street.
yeah.
All right. Well, the best thing you could have done is leave it alone. Do you both still live in Constantine?
I'm not too sure about him. I live in Constantine for the time being. I actually just got approved for an apartment in Sturgis, so I'll be moving there in July, hopefully.
Good. You guys won't have a reason to have any contact. You got arrested on October 28th and you posted bond the same day. I don't believe you ever missed a court appearance. So I think you got 1 day in jail credit, 1 day. Does that sound right? Mr. Black, does that sound right to you?
Yes, sir. Sorry about that.
I'm just going to do the standard fine and cost. The prosecutor generally understands what that is. $75 fine, a $75 crime victims' rights fee, $50 state minimum fee, and $150 attorney fee. That adds up to $350. Jordan, if you could talk with Ms. Green, that would be helpful. They've got her back there.
Yeah, I just haven't heard from the prosecutor.
Oh, yeah, you will. So we still have the same problem we had before. All right, you posted $100 of bond. So that's $250. The prosecutor's not here yet. So you owe $250. Can you pay that now, or do you need a payment plan or time to pay it?
I don't need a payment plan, but like I don't have cash on it right now.
All right, well, I'm gonna give you 30 days to pay it. I'm gonna make it due by July 7. You can pay by certified check or money order, cash, credit card. All right, this matter's done. You don't need to be here for jury trial next Wednesday. I will send an email to the clerk. According to Mr. Nossinger, he's kind of lost track of his client also. So we're going to call off the jurors for Wednesday, June 10th. All right, Mr. Black, you're good to go. Thank you.
Thank you, Your Honor.
Tim, you have anything else for me?
Not quite.
Hello. We've yet to catch up with the prosecutor, so
Oh, you didn't hear?
no.
I can't hear.
At 9? Well, we better move fast.
I know.
Yeah, the lawyers all tend to get here early, and sometimes we have to wait for the prosecutor to get here. We're set up by 8. Todd, did you know the song? What? Did you know the first line of the song?
Yeah.
Okay, I figured you would. You're the age where you would know what that song is.
Alrighty, once again, good morning, everybody. TCF Live on a Super Friday. I hope your day is starting off well. It is here in the bunker. Sun is shining, birds are chirping, and we're only heading up to a high of 111 degrees, I think, today. So mild day here in the desert. Might take a minute for Judge Middleton to rack up his next contestant. So let's go over to the 44th District and the Magistrate Court. I forget this magistrate's name, though, to be honest. If you remember what it is, put it in the chat for me, because she doesn't have it displayed.
Arraignment on this because I have a conflict of interest.
Okay.
And he said now is a good time to log on to his courtroom. But
Okay.
we have your 846 ready, right?
So yes, 846 is ready. So Your Honor, should I speak with my Miller now on this Zoom and then we log on to judge's Zoom, or?
I'm going to call the case, set forth my conflict of interest, then we'll send Mr. Miller up into Judge K's Zoom.
Judge K. Okay.
And then
Judge
you'll
K.
go to Judge K, and then I will do Richardson, and then you'll go to Judge K.
Got it.
Hey, Madam Clerk, got it? Calling the case number of 2600680. This is the case of the City of Berkeley versus Michael John Miller. Your appearances, please. That means please state your name.
Edith Blakeney on behalf of Michael Miller, Your Honor. Mr.
Mr.
Miller,
Miller,
please.
please state your name.
Michael Miller.
Okay, I am Magistrate Joe Banky. I've reviewed the file. I have a conflict of interest. The alleged victims are my neighbors. So because the magistrate has a conflict of interest, I'm recusing myself on this case. And the trial judge, Judge Kowalski, will conduct the arraignment. Mr. Miller, you, I'm going to give you a Zoom ID. Do you have a piece of paper and a pen?
Yeah, hold on, let me get a pen.
Ms. Blakeney, I'm going to give you the Zoom while you're waiting.
Oh, I know Judge K's Zoom. Thank you, Your Honor.
You have it memorized?
I have a whole
If it
sheet.
isn't live, it's Memorex. Okay, Mr. Miller.
Okay,
Okay, listen, you're going to log off this Zoom and then you're going to join Zoom again. And you're going to put in this Zoom ID, 831-029-3441.
okay. 831-029-3441.
Yes, and then Attorney Blakeney is going to join you on that Zoom in a few minutes and you'll talk about the case, okay?
Okay, thank you. How do I log out here?
Here, I'll help you leave. It's today, I'm sorry, 6/5, thank you.
I can't hear you. Uh-oh, there it goes.
It's muted. Okay, so we're gonna call Miss Richardson's case, please. And then Miss Blakeney, you'll log off and I'll kind of manage your docket here and keep everyone informed. Thank you for accommodating.
Thank you. No problem.
Case call, are you ready, Madam Clerk? 2600693. This is the City of Royal Oak versus Stephanie Lynn Richardson. Your appearances, please.
Good morning, Your Honor. Edith Blakeney on behalf of Stephanie Richardson, Your Honor. My client agrees to participate virtually. Ms. Richardson, can you state your name for the record?
Stephanie Lynn Richardson.
Good morning, ma'am.
Your Honor, this is the date and time scheduled for arraignment. My client does stand mute, does waive a formal reading. I have gone over her constitutional rights to trial with her. And lastly, she is requesting MIDC attorney.
Okay, the court will waive the formal reading based upon your representations. Defendant stands mute. A not guilty plea is entered on her behalf. Her request for assigned counsel, can you lay a basis for that, please?
The basis for assigned counsel, she's requesting assigned counsel. So she
Wait,
does
let's-
work. Ooh,
Go ahead.
she is 57. She does work for the Oakland County Schools, full time. So we're requesting that.
I know, does she qualify for assigned counsel is my question.
I don't have her financial information, so
Okay, so
technically,
I
know
will
there's a
assign
form.
it. Okay, I'll assign it temporarily subject to defendant completing the form. Okay,
And she can access that online at Royal Oak District Court.
okay, and, okay, so is the Gardenia Avenue a good address for you, ma'am?
Yes, it is.
Okay, and could someone chat me a phone number or
I
state
will,
it?
Your Honor. And
Okay,
I did
thank
chat
you.
an email address as well,
Oh, you did? Okay, let me look. I didn't get the chat.
but I
Wait,
did not
wait.
do the telephone number.
Okay.
It's
The other magistrates, I changed the settings on here and
okay.
say that the type is microscopic. Either comes in where it's gigantic or it's microscopic, but I'm gonna do my best. Okay, so I have received a Hotmail email that I'm copying into the ROA. And I've received a phone number ending in 7452. Thank you, sir.
Correct.
Okay, and okay, so I have updated. What do you have to say about bond and bond conditions?
Your Honor, my client is 57 years old. She's worked full-time for Oakland County Schools for the past 4 years, no criminal history, or has communicated no criminal history, has 3 adult children, is married. Your Honor, for those reasons, we are asking for a personal bond.
Okay, do you know the date of the incident versus the date of the issuance of the citation? Or
Your
the-
Honor, I have an offense date of 4/29 of this year, excuse me, at 5/42, and it says the entry date is 4/30/26. And that's all that I have.
Okay. All right, the court is setting a $7,500 personal bond with conditions. No money is due at this time. And you are to personally appear for an exam, arraignment, trial, or sentencing. You shall abide by any judgment under, in this case, surrender to serve any sentence imposed. Do not commit any crime while released. You shall immediately notify the court in writing if your address changes from Gardenia or the phone number 7452 changes. You are not to use alcohol, marijuana, or any other illegal controlled substance. You shall alcohol ETG test 1 time per month. With pretrial services, do you have a piece of paper for the number?
Yes.
Okay, the phone number is 248 15.
So I've got 248.
It takes 1 business day for pretrial services to get the file from this court. So because they will not have the file today, the earliest they'll have it is Monday afternoon. Therefore, defendant, you must contact pretrial services by Tuesday, what is 9/10? Tuesday, June 9th, 2026 at 3:00 p.m. to set up testing.
Okay.
And if you call today, they won't know who you are. That's why I give
Okay.
you time. And the bond is 7,500 personal, and you must complete the financial form to demonstrate to the court that you qualify for assigned counsel. Okay?
Okay,
We're going to set this matter for a pretrial. You have Judge Meineke. He's conducting the pretrials by Zoom. You'll receive a notice to appear in the mail. It'll have a different Zoom ID than you used today to log on. So please log on to the proper courtroom at the next date and time. Ms. Blakeney, is there anything further requested or required of the court on behalf of Ms. Richardson?
No, Your Honor. Thank you.
Okay, thank you, Ms. Richardson. This concludes your arraignment, and you may leave the Zoom.
Alrighty, friends, good morning once again, TCF Live. It is a Super Friday. It is good to have you here. Let's change it up. Let's go to Lubbock County, Texas, and this is their first appearance court.
She can put it in, we can shoot an email.
Okay, so I'll also talk to pretrial services. I'll send them an email telling them you don't want to be considered anymore. But you might ask your pod officers if there's a way that you can pull that request. Okay, do you want a copy?
Yes, please.
There you are. Thank you, ma'am.
Thank you. I'll get that back for you.
Yes, ma'am.
Okay, thank you, guys.
Enrique Rios. Enrique Rios. There's a fly in here. Oh, can you come up here? Need a fly swatter. All right, Mr. Rios, can you hear me okay now?
Yes.
Okay. We have your name spelled Enrique, and then your last name Rios,
That's correct.
and your date of birth to be July 23rd of 1967.
That's correct.
You have been indicted for possession of a controlled substance, penalty group 1 or 1B, less than a gram. It is a state jail felony. The indictment reads that on or about, did you get it?
Sorry.
Awesome. On or about April 11th of 2026, you intentionally and knowingly possessed a controlled substance, namely methamphetamine, in an amount of less than 1 gram. I am entering a plea of not guilty for you. I show your bond to be $2,500 and your attorney to be Maritza Ferraro. Do you have any questions?
I just wanted to say that it was just a pipe.
Okay, we'll talk to your attorney about that. If you have a defense, she'll let you know, okay? You want a copy?
Yes, ma'am.
There you are. Thank you,
Thank
sir. Oh, you can head back.
If you go back out.
Barbara, thank you for the $10. Let's get this party started. Thank you so much. And Ashley, 14 months now as a member. Thank you, TCF. Love you all. We love you too, Ashley.
Gomez, we have your name spelled Marcos and then your last name Gomez. Okay. And your date of birth to be May 25th of 1991. You have been indicted for possession of a controlled substance, penalty group 1 or 1B, less than a gram. It is a state jail felony. The indictment reads that on or about April 20th of 2026, you intentionally and knowingly possessed a controlled substance, namely methamphetamine, in an amount of less than 1 gram. I am entering a plea of not guilty for you. I show your bond to be $3,000 and your attorney to be Alexander Nunez. Do you have any questions?
No, ma'am.
You want a copy? No? All right. You're free to exit. Antonio Villareal. Mr. Villareal, we have your name spelled Antonio, and then your last name Villareal.
2 R's straight.
Oh, there is in Villareal. Okay, let me make a note of that. All right. And your date of birth to be September 26th of 1971. You have been indicted for possession of a controlled substance, penalty group 1 or 1B, less than a gram. It is a state jail felony. The indictment reads that on or about April 23rd of 2026, you intentionally and knowingly possessed a controlled substance, namely methamphetamine, in an amount of less than 1 gram. I am entering a plea of not guilty for you. I show your attorney to be Reese Scruggs and your bond to be $30,000. So this is a new charge. I don't know about the probation violation. So if you have questions about that, Mr. Scruggs should represent you on that as well. Mhm. Yeah. Do you want a copy of this? All right, there you are. Thank you, sir. You as well. All right, these are all out of the 140th District Court with Judge Freitag presiding. Arnold Aguirre, if you'll stand for me. Mr. Aguirre, we have your name spelled Arnold, and then your last name Aguirre. And then we have you listed as a junior, is that right? And your date of birth to be February 29th of 1980. You have been indicted for possession of a controlled substance, penalty group 1 or 1B, 4 to 200 grams, as well as evading arrest or detention with a vehicle. The possession is a 2nd-degree felony and the evading is a 3rd-degree felony. The indictment reads that on or about March 4th of 2026, you intentionally and knowingly possessed a controlled substance, namely methamphetamine, in an amount of 4 grams or more, but less than 200. And then count 2 is that on the same date, while using a vehicle, intentionally fled from Angel Carrillo, a person you knew as a peace officer attempting to lawfully arrest or detain you. There are 2 enhancement paragraphs that state you have previous felony convictions. The first is May 18th of 2005 in Lubbock County for aggravated assault with a deadly weapon, as well as July 10th of 2018 in Lubbock County for possession of a controlled substance. I am entering a plea of not guilty for you, $1, but that you don't have an attorney. Did you talk to Mr. Tiarina about getting an attorney?
No.
Okay, so it's in the works. When did you talk to him? Yesterday? Okay, so you should have an attorney by the end of today. All right, just check with your pod officer. You should be able to check that on your tablet. Maybe wait till the end of the day and see what it says. Okay, do you want a copy? All right, do you have any questions? All right, you're free to exit the courtroom. Thank you, sir.
Tot, thank you for gifting 5 memberships. I appreciate it. Ashley gifting 14, probably because it's 14 months for her as a TCF member herself. Thank you so much, Ashley. Appreciate you as well. And Bin Chickens, officially a channel member now. Congratulations. Join us for the pre-show. It's all sorts of fun. Okie dokie, let's change it up again. Let's go to Lansing, Michigan. Judge Flores.
On the record in docket 2601341, that is People of the State of Michigan versus Keith Rembert. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Oakes.
Michael Oakes appearing on behalf of Mr. Rembert.
And sir, you are Keith Rembert, is that correct?
Yes, sir.
All right, thank you. This is the time is set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. At this point, the people do have necessary witnesses ready to proceed. It's my understanding that Mr. Oakes will be requesting an adjournment. The people are not in a position to be able to agree to that adjournment.
Mr. Oakes.
Thank you, Your Honor. Your Honor, this is our first time coming before this court requesting an adjournment. At this time, I was most recently advised that my client made contact with someone who has possibly some footage from their Ring door camera footage. This is something that he's been trying to obtain to help out in this situation, give us a better insight as to what actually transpired here. So we're asking for time for us to be better prepared for this preliminary examination so we can most adequately question the witnesses that they have alleging these allegations.
And Ms. Fortuna Gill, when did you hear of this new discovery information?
This morning, Your Honor.
And how many witnesses do you have here?
I have 2 witnesses, one being law enforcement
Okay.
and one being a lay witness.
All right. And so you don't want to adjourn the prelim because
I am hesitant to adjourn agree to adjourn.
with one lay person.
Yes, because the complaining witness, she doesn't reside in Lansing full time, and additionally has some medical issues that require some out-of-state treatment sometimes. So I just think she's able to be here today. That's all, and I'm not sure how.
We
future
can
date may work.
start the prelim and get the one witness so that she doesn't have to come back and then offer cross-examination and then adjourn the prelim for future discovery.
And I anticipate that I would want to question as to what I see on the video from that one witness. We most definitely are open to flexibility with the scheduling as far as getting her back scheduled around anything that she has going on. But I most definitely believe that she would need to be questioned as to what we're observing here.
So Mr. Rembert be willing to waive his right to a prelim within 21 days, which would allow some flexibility.
Yes,
Gotcha.
most definitely.
With that understanding, I think that would be able to concede to the witness being here, and we have additional discovery. All right. All right, Mr. Oaks, may I inquire of Mr. Rembert of his waiver of the 21-day rule?
You may.
All right. Mr. Rembert, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that the crime is committed and the identity of the person who committed that crime. You are represented today by attorney Mike Lokes, and you would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Is it your wish today to waive your right to a prelim only within the 21-day period? You wouldn't be waiving your right to a prelim in general, just within 21 days, so that Mr. Oaks can be given the future discovery, more discovery, and then we can see how it can work with the victim's schedule concerning the preliminary examination. Is it your wish today to waive your right to a prelim within 21 days?
Yes.
Do the people also waive their right to a prelim within 21 days?
Yes, Your Honor.
All right, I find the waiver of the prelim to be knowing, voluntarily, and accurately made. And then I will, you can, because I don't want to set a date and then have to move the date. So you should see what dates are available with a victim coming in. But we will reschedule the preliminary examination. And it also make sure that that date works with Mr. Oaks' schedule, because Mr. Oaks also has a trial schedule. And then we'll come back and put it on the record concerning the rescheduling and then make sure that date works with your victim. That would probably be a Friday sometime, a Friday, and then make sure it works with Mr. Oaks' schedule.
Will do, Your Honor.
All right.
And we will let, should we just let Marcy know?
Yeah, just let Marcy know, and then we'll reschedule accordingly with everybody's schedule, now that the 21-day has been waived.
All right.
Anything else for the record in 26-01341, Ms. Fortuna Hill?
Not for the people.
Mr. Oaks?
None, Your Honor.
All right. Mr. Rembert, we'll see you. You'll get notice to appear based on Mr. Oaks' schedule and the complaining victim's schedule, okay? You should be all set. Thank you.
Thank you.
That one still needs to be scheduled.
Okay, we are now ready on Guadalupe, Lara.
All right. Rembert. All right, so we're on the record in 26-01381. That is people of the state of Michigan versus Guadalupe, Lara. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Rothstein.
Good morning, Your Honor. Vita Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. Lara, who is present in the courtroom and standing to my right.
And sir, you are Guadalupe Lara, is that correct? All right, thank you. This is the time set for preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor, it's my understanding that the defendant wishes to waive his right to a preliminary examination. Today, the people would do the same. There's an offer to be placed on the record. That offer will remain open till the first pretrial and circuit court. The offer is, excuse me, to plead to a domestic violence third and for the possession count to be dismissed.
And is that your understanding, Ms. Rothstein?
Yes, that, and I guess presumably the count two would be dismissed as well.
That would be true, yes.
Okay, so the offer's been placed on the record. It'll be open until the first circuit court pretrial. I'm assuming pretrial, since we don't know what judge it's going to. But the offer's been placed on the record, and that's your understanding. May I inquire of Mr. Guadalupe of his unconditional waiver?
Mr. Lara, yes.
Lara, yeah. All right. Guadalupe, Lara, you understand that you have a right to preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Vita Rothstein, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it would be your wish to waive your right to preliminary examination. The terms of the offer have been placed on the record, and this offer will be open to the First Circuit Court pretrial. Is it your wish today to waive your right to a preliminary examination in general?
Yes.
Do people also waive their right to a preliminary examination?
Yes, Your Honor.
Yeah, I find the waiver of the preliminary examination prelim to be knowing, voluntarily, and accurately made. And I'll provide the bind over documentation for the signatures of the parties. Take this and get the party signatures. Thank you, Brendan.
I'm notorious for doing that every single time.
Me too.
Thank you, Brendan. All right, so I'm in possession of the bind over documentation on 33-26003247. It's actually 26-01381. Signed by all the parties. I'm going to indicate the examination was waived on today's date, which is June 5th, 2026. Anything else to come to the court's attention before I sign the bind over documentation for Tunico?
Not for the people.
Ms. Rothstein.
No, Your Honor, thank you.
All right. I'm going to sign the bind over documentation. So, Mr. Lara, your time in district court is done. You're off to circuit court. Will you get your next notice to appear from your attorney, Ms. Rothstein? Okay, sir? All right. All right, Mr. Lara, you're all set. Thank you for your appearance today. Thank you.
Alrighty, friends, let's go down to Florida. Wade Mercer starting his day.
Good morning, ma'am. I think it may be Turner now, that your grandmother just told me, but it was Summerlin at the time the VOP file was done. It's Savannah Summerlin Turner, is that correct?
Yes, it's Savannah Turner.
Okay, ma'am, so Ms. Turner, you're here because you've been accused of violating in terms of your state probation. Your grandmother is in the courtroom. Ms. Turner, the accusation is that you tested positive for methamphetamine/amphetamine back on June 2nd, and it was conferred. Hang on a second. Mr. Mitchell. This doesn't make any sense. You see what I'm seeing?
I think that may be a typo.
It says a sample was obtained from you on June 2nd, which will be a really quick warrant turnaround. And then it was confirmed by a lab on May 16th. I know the lab may be quick, but I don't see how they can confirm it before you even submit it. So I think it's a typo. I think the probation officer just probably made a typo where they've got the wrong date on here. What I'm going to do, Judge Garcia signed a no bond warrant. I'm going to ask Mr. Mitchell to notify the probation office of what appears to be an error in the dates, ma'am. And we're going to see if we can get it straightened out. But there is a no bond warrant. I'm going to get you arraigned this morning. What that means, Ms. Turner, is I want to get you an attorney appointed to represent you if you want one. Would you like to have an attorney appointed to represent you in this VOP?
Yes, sir. But Ms. Clark told me to, Ms. Clark told me to say, to let you all know at first parent that, my grandma can explain it better to you. That,
I couldn't hear you. Say that again.
To get like extra, like care classes and drug classes and be on like 7-7.
She wants her probation reinstated. She says her probation officer said at first appearance they'll reinstate her probation. I advise her that's not going to happen. It's not going to happen. I'm not saying it won't happen eventually. I'm saying I'm not going, it's not even my case, number one. Number two, if you've got a tested positive for meth on probation, you're probably right where you need to be, at least for some period of time. But we'll see what happens when you get over to Judge Garcia's court. You've got no bond for the time being, and you said you did want an attorney appointed. Is that correct?
Yes.
I'm going to appoint the public defender's officer to represent you. Ms. Turner, listen to Mr. McDaniel, and we'll see if you have any questions in just a minute.
I'm going to plead not guilty, Your Honor. Set this on the July 9th court date, and I advise your attorney to come by and speak to her prior to that hearing.
Great. July 9th. Mr. Mitchell, anything?
No, Your Honor.
Ms. Turner, do you have any questions?
No.
Ma'am, in the courtroom, do you have any questions?
Yes, ma'am. Yes, sir. I have two boys, 11 and 2, 11, yeah, it's 3 now, 11 and 3. And they live in my house, but, and she give me something, I can take them doctors and stuff.
So your grandmother's concerned about needing something for like healthcare and educational purposes for your 2 children that she has. So ma'am, they allow visits for stuff like that at the jail. What I would do is, it's your responsibility to get whatever you want her to sign. The jail doesn't have forms as far as I know. But if you get something for her to sign, whatever, may want to contact the family law attorney, and see if there's a form they can give you, and then you can take it to the jail and get her to sign it. You would need to contact the jail before you go to make sure the visit's approved. Okay? Yes, ma'am. Yes, ma'am. Yes, ma'am. So your grandmother's going to try to get something for you to sign so she can make sure your children are taken care of from a medical perspective while you're in there. Okay? Thank you for coming, ma'am.
Come on, sir.
I see we've got Mr. Wright today. I started to say Judge Wright. It was Judge Wright for many years. Judge, do we have one that you're here on the day, sir?
Judge, I'm just a spectator, but I'm friends with Mike Braxton on the docket this morning and just wanted to speak on his behalf, if that's allowed.
Sure, let's take that case next. Michael Braxton. Mr. Braxton, you're here in accused of 1 count of battery on a person 65 years of age or older. Mr. Braxton, I read the complaint. It's an unusual complaint. There is probable cause for a crime, but the 2 witnesses plus yourself all say that you were struck first, you were slapped first, and that you responded by slapping this person. And then in the alleged victim's version, let me not paraphrase, say what the complaint says. In her version, she says she pushed you away and then you struck her. So it's not real clear. The officer made a charging decision that he or she made and chose to arrest you and not her, even though there are 4 people that say she initiated contact first. So it is what it is. Mr. Wright, anything that you want to add to that, sir? Anything else I need to know?
Judge, Mr. Braxton and I have been friends since high school. He's at least 70 years of age himself. And I know he would not do anything like this unless he was struck first. He's a very good candidate for a conditional release. He was born and raised in Jackson County. He lived his whole life in the Panhandle here. And so I would just ask that you give him a conditional release, and maybe they can get this straightened out later.
Thank you. So, Mr. McDaniel, I'm showing no prior criminal history also. Is that what you're showing too?
Yes, Your Honor. Yeah, he's never been in trouble before. I know Mr. Braxton.
Thank you. Mr. McDaniel, anything else on behalf of Mr. Braxton?
We just asked for maybe a monetary cash bond.
So he would prefer a cash bond as opposed to a conditional release?
Yes, Your Honor.
Mr. Mitchell, what's the state's position?
No objection to a cash bond, and if he decides he wants a conditional release, we don't object to that either.
So, thank you both. Mr. Braxton, I'm gonna let you pick between a conditional release and a cash bond based upon your lack of any prior history, as well as what the complaint alleges and what the witnesses say, as well as what the alleged victim also says. If you prefer the cash bond, it's gonna be $250 cash. If you prefer a conditional release, I'm glad to grant you the conditional release. Now, there's going to be a condition of no contact with her, the alleged victim, and her residence. But now you may not know the answer to this, Mr. McDaniel. It appears it's a little unusual. The address on the complaint for her is not the address at the boat ramp. So I don't want to have problems in the future with him going to the boat ramp if that boat ramp is next to her home. So her address is 331 Lake Point Road, which is further down. And the address by the boat ramp is something different. So, Mr. McDaniel, do you have any idea? Does the alleged victim live by that boat ramp? I don't want to have future problems.
Well, it used to be an old restaurant. Yeah, Your Honor, I mean, it's the public boat ramp. I mean, so I'm not sure.
I have no intentions of going back to the boat ramp, Your Honor.
Okay, that makes it easy. That makes it easy, Mr. Braxton. What I'm going to do is I'm just going to keep you away from her home or 500 foot of her home. So if that's a neighbor's property that she's at by the boat ramp, that's you could go to the boat ramp. I just don't know. According to the complaint, she kept saying it was her property. So I don't know if she has an ownership interest or something. But for the time being, on a temporary basis, I'm going to require you to stay away from that boat ramp, 500 feet of her home, and then if that becomes an issue later in the summer and you want to go there, we'll try to figure it out. there may be one other public boat ramp on that side of the lake that I'm aware of, but it's a very small, narrow one that you got to back down about a quarter mile to get to last time I was there, which has probably been 20 years. Mr.
Boat ramp is extremely close to the property. Yes, it is a narrow, it's right down the property lines of the neighbors there. I mean, it is a tight spot where this boat ramp is.
Well, there's the one this supposedly happened at is the one with the old restaurant, correct?
Correct.
Yeah. Yeah, that ain't the narrow one. The narrow one's further to the north, I think. But anyway, Mr. Braxton, I just don't want things to get worse than they already are. So I'm going to ask the jail to give you a notice for your court date. Right now, that notice will be for July 7th at 8:30. They'll give you that written notice before you leave the jail. And as soon as that, he chose the cash bond, Mr. McDaniel, is that right?
Yes, Your Honor.
As soon as that cash bond is posted, you'll be free to leave. Mr. Braxton, do you have any questions?
No, sir.
Mr. Wright, anything else?
No, sir. Thank you, Judge.
Thank you, sir. Mr. Mitchell, anything?
Nothing from the state. Your
Thank you. It's good to see you, Judge. Have a good day.
I'm not positive that it is a public boat ramp. I'll be honest with you. I think that it's private. But that's here nor there.
I'm not
You're not going back in.
Yeah, I think everybody uses it. So I think it's public. I think both of them are public. Okay, so wish you the best, sir. The next case is, we do have friends or family here on Abigail Hunter. So let me call that case next. Miss Hunter, good morning. Miss Hunter, you're here because you've been accused of one count of battery domestic violence. Your boyfriend is in the courtroom on your behalf, ma'am. Miss Hunter, I've read the complaint. There is probable cause for the charge, but the good news is I think you have no prior criminal history, Miss Hunter, at all. Is that correct?
That's correct.
So, Miss Hunter, the biggest question I've got to ask you is I need to try to get you out of there, but
I have somewhere to live. Oh.
that's going to be the question. Is it your grandmother, according to the complaint, your grandmother doesn't want you back there, so do you have somewhere else you could go on a temporary basis?
Yes, sir, I do. And I
Where would
also
that
have
be?
a Section 8 voucher. I have a friend's house I can stay in, and I have a Section 8 voucher, but I have a place I can stay in until I'm approved.
Where?
Right there on Old Spanish.
Okay. So what's going to happen is someone's going to verify you have a place that you can live at before I consider a conditional release. Okay. Just be aware of that. Mr. McDaniel, anything else on behalf of Ms. Hunter?
Judge, I was going to question the probable cause of this. I mean, I think it's undisputed facts here. I mean, some of them are not in here that she's lived with that grandmother for 3 years. She lives there. Sister does not live there. Sister lives down the road.
With her husband.
Quit talking. Sister comes to this house to basically throw her out of her grandmother's house, in a unlawful way, grabs a hold of her kids, both kids, and throw them, a 2-year-old and a 3-year-old, and basically throw them out in front, the front yard. I question whether there's probable cause for anything here, Your Honor. And I'm just going to throw that out there, Your Honor. Someone with no history and those type of facts, and I don't think they're uncontested facts. I think the sister admits that she did that in the complaint, that she grabbed a hold of the kids and taken them outside.
Yeah, that's not in the complaint I've got, but I'll read that complaint out loud in just a second here. Mr. Mitchell, what's the state's position?
I'm looking at it right now. I mean, if you want to take time to read the complaint.
Yeah, what the complaint says is, according to the alleged victim, Cheyenne went into Abigail's room to tell her she needed to leave the residence. While in Abigail's room, Abigail's children were in the room. Cheyenne stated that while arguing with Abigail, she picked up one of the children. Cheyenne alleged at this point is when Abigail punched her with a closed fist on the left side of her head near her eye, which left a visible mark. So it doesn't say anything about taking them out in the yard or anything. That's not in here. I think there's probable cause. Now you need to understand, Ms. Hunter, probable cause is a very low burden, very low. Does not mean you're guilty. What it means is there's enough evidence under an oath in a sworn complaint to allege the elements of the crime and to lead a reasonable person to believe you may have committed the crime you've been accused of. Does not mean you're guilty. But Mr. McDaniel's exactly right. This is there's a lot of issues in this complaint, a lot of potential defenses, and those are going to be very, very relevant in what I do with the bond situation in just a second or the conditional release. But as far as probable cause, I think there is probable cause. I'm convinced there is. So, Mr. Mitchell, I don't know if I got to the point of asking you what your position was on bond or release.
I was going to say that, I think there is enough for probable cause, but you pointed out that there may be potential defenses that come with this. If she wants to take a conditional release, we don't object to that. Or if she wants to do a cash bond, no objection.
Mr. McDaniel, what's her preference?
That's the only question is whether the boyfriend can pay the cash bond. She works at Walmart, but I don't know when she gets paid and, yeah, I'm not sure. And
So let me tell him, so sir, what I'm gonna do is let her pick between a $250 cash bond or a conditional release. So here's how a cash bond works. If the cash bond is posted and if it is dismissed, the money is returned to whoever posted the bond. Okay, but if the cash bond is posted and it's not dismissed and she's ordered to pay court costs and fines, the money then goes to court costs and fines. So if someone posts a cash bond, they may get it back, they may not. Her other alternative is called a conditional release. A conditional release has more reporting requirements. So it's more strict than the cash bond. She's got to report in. She can be drug tested. She can't possess or consume alcohol. So it has more rules to follow than a cash bond. So you're going to give her that choice. What I'm going to suggest, sir, is you're going to talk to the jail. If you decide to post the cash bond for it, it's $250 cash. And just let the jail know, or do you already know what you want to do? Okay, your boyfriend says he's going to pay the $250. And as soon as that's posted at the jail, she'll be released, sir. So Ms. Hunter, as soon as he posts that, you'll be released. Just have no contact with the alleged victim or that property for the time being. Now, if your grandmother wants you back there and your sister doesn't live there, I have no problem with that. But according to the complaint, as of yesterday, she did not want you there. So that's what we're going with right now.
No problem.
All right. Do you have any questions, Ms. Hunter?
No, sir, I don't.
The jail also will give you a notice for your court date. That will be June 29th at 9 a.m. Ms. Hunter, they'll give you that notice before you leave the jail. Sir, do you have any questions? In the courtroom, sir, do you have any questions? He's texting.
Do you have any questions?
Do you have any questions? All right, he's trying to get your bond set up. So wish you the best, ma'am. Thank you for coming, sir. All right, so Mr. McDaniel, that's it for friends or family in the courtroom. We can go back to whoever's next on our list, which appears to be Sonia Smith.
Judge, very quick, I just received a response from state probation regarding Savannah Summerlin. They said that was a typo.
They're gonna fix it?
They're gonna fix it, yeah.
So Mr. McDaniel.
Pause real quick, guys, between cases here, because the question just came up in the chat. Is it bail or is it bond? So bail is the amount of money the judge sets to allow someone to get out of jail. Bond is the financial mechanism used to pay that bail. So that's the difference between them. Education completed. Let's continue with Judge.
I'll wait till he gets to speak in with Ms. Smith. Sure. Mr. McDaniel, Mr. Mitchell said that he got a text from state probation. They're going to fix the typo in Ms. Summerlin or Ms. Turner's affidavit. Ms. Smith, good morning. You're here because you've been accused of one count of petty theft and one count of battery domestic violence. Ms. Smith, there is probable cause for both these charges. It appears that there's actually you've got prior felony battery based upon prior, so that this battery may turn out to be a felony. I have not looked at prior thefts, but we're going to assume that's a misdemeanor. So, Ms. Smith, there is probable cause. Your criminal history is horrible. You've been to prison 7 times. Most
6.
recently got out of prison. I'm sorry, ma'am.
6.
Yeah, I'm looking on by the Department of Corrections website. For bond purposes, if it is 6, I'll give you the benefit of the doubt. We'll say it's 6. Doesn't change the bond. I'm going to set you one bit. You got out of prison most recently the month before last, about 40 days ago, and now you're back in jail, accused of a new crime. So that's the background I have. I'm going to listen to the attorneys and I'm going to set your bond. Mr. McDaniel, anything?
Thank you.
Yes, ma'am.
I don't have anything. This is, yeah, I don't have nothing on it.
All right, Mr. Mitchell.
Nothing at this time, Your Honor. I am seeing a prior battery in her history, so it may be treated as a felony and transferred up.
She has a prior felony battery based upon,
Yes.
that's what she just got out of prison for, based upon priors. So, Ms. Smith, your bond's going to be $5,000 on the petty theft, $10,000 on the felony battery. Excuse me. It's a battery, but for bond purposes, I'm setting you a felony bond because you just got out of prison and it's for the same charge. Your total bond today, Ms. Smith, is $15,000. You have a condition of absolutely no contact with the alleged victim, ma'am. And I'm going to ask the jail to give you a notice for your court date. Your court date will be July 7th at 8:30. You will get to use the phone in a few minutes, ma'am, to try to post the bond. Ms.
June
Smith?
29th.
As of now, June 29th, but I'll more than likely file a
Oh, I'm
transfer.
sorry.
Yes.
Thank you both. So right now, your court date will be June 29th, because right now it's a misdemeanor. If the state takes it to felony court like they did the last case, then it would be July 7th. Any questions, Ms. Smith?
Jake, y'all interested in just go ahead and sentencing her to 11/29 in jail?
Yeah, if she wants to open plea, we have to make contact with the victim in this situation, but if she
Same
pleads
mother,
straight up
so-
to the court,
It's her mother and her
Same one
daughter,
with
same
prison
time it
for.
was that felony last one, so it's up to y'all. I'm just,
from the state's perspective, I don't feel comfortable doing that today, but she's more than free to plead straight up to the judge if she wants to.
Well, you can stop. She doesn't have the right to plead straight up at first appearance if the state says they're considering a higher charge. So she can plead straight up if you say that you're not considering a higher charge. So you still have control in this particular
Yeah.
circumstance either way. So are you going to look at a higher charge, or you just want time to talk to the alleged victim before you do it either way?
Let me talk to the victim and let me talk to Mr. Gill first. And
So do this. If you talk to Mr. Victim and alleged victim, Mr. Gill, and you decide to leave it in misdemeanor court, please let Mr. McDaniel know that, because he wants to start getting her gain time as soon as possible. So Ms. Smith, I may see you in the next few days, ma'am, once Mr. Mitchell has a chance to look into the case, okay?
if so, we can bring her back up on Tuesday when Judge Garcia is covering.
That's no problem at all. No problem at all with me from that. Okay. Have a good day, ma'am. 2, 3, 4, 5, 6, 7. DOC website shows 7. Next case is Willis McKinney. Mr. McKinney, good morning. Mr. McKinney, you're here because you've been accused of 1 count of lewd lascivious molestation on a child less than 12 years of age. Mr. McKinney, there is probable cause for this charge. I've read the complaint. It's extremely concerning, especially when you consider the prior charge you have for this and then the other prior allegations that were uncharged. So it's a life felony. It's a very serious charge, Mr. McKinney. I think you're entitled to a bond as far as I can tell. And I'm glad to set that bond, but I'm going to listen to the attorneys before I make a final decision. Mr. McDaniel, anything on behalf of Mr. McKinney?
this is reasonable bond, Your Honor.
Mr. Mitchell?
Nothing at this time, Your Honor.
Mr. McKinney, based upon your prior similar charge, your bond's going to be $100,000 cash or surety. You have a condition of no contact, no unsupervised contact with any minor at all. Mr. McKinney, you'll get a chance to use the phone in just a minute, sir, to try to post the bond. You'll be also given a notice for your court date. That will be July 7th at 8:30. And if you do post the bond, just remember the conditions I've imposed on you about contact with minors. Mr. McKinney, do you have any questions?
Who's that?
Have a good day, sir.
Contact with minors and no contact with the victim.
She's a minor, so she would be fit in that. She's
Okay.
9 years old, so yeah, she'd fall in that definition.
Okay.
Hey, you know what? I need to clarify that. No contact with the victim at all, whether supervised or not. Thank you, Mr. Mitchell. You're right. I need to be clear about that. So the unsupervised applies to anybody else. Her applies, I don't care if supervision or not, he can have no contact with her. That brings us to Nathaniel Hamby. Mr. Hamby, good morning. You're here for an out-of-county warrant out of Orange County. Mr. Hamby, that warrant has a purge amount on it of $4,000. It's a child support matter. What that means is that if you post the purge, you'll be released. You go to court later. If you're not able to post the purge, that county will pick you up, Mr. Hamby. When they pick you up, you'll be transported down there. Then you go before a judge or a hearing officer. Once you get there, you will get to use the phone in a few minutes, sir, to try to come up with the funds to post that purge. Do you have any questions?
Yes, sir.
Have a good day, sir. $4,000 purge on the warrant or the order. Then we have Cameron Crutchfield. Ms. Crutchfield, good morning. You're here accused of 1 count of resisting an officer without violence. The complaint alleges actual violence, but the officer chose to charge you with without. That's his or her call. There is probable cause for that charge. I'm appointing the public defender's officer to represent you. Please listen to Mr. McDaniel, your attorney.
Your Honor, I swear to Ms. Crutchfield, she's going to plead no contest to charges listed. You understand, 90 days in the county jail, 1 day jail credit, $370 fine. And she has signed her plea waiver form, waiving right to jury trial and call witnesses.
Thank you. Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Ms. Crutchfield, did you hear that agreement? You have to answer out loud, Ms. Crutchfield.
Yes, sir.
Ms. Crutchfield, is that the plea you would like to enter?
Yes.
Ms. Crutchfield, I'm going to accept your plea of no contest to the charge of resisting an officer without violence. Ms. Crutchfield, I'm going to judge you guilty of that offense, sentence you to 90 days in jail, give you credit for the time that you've already served, which is 1 day. I'm going to order court costs and fines, Ms. Crutchfield, in the amount of $370, ma'am. Ms. Crutchfield, I'm sure Mr. McDaniel's already explained this to you because he always does, but there's a trustee program at the jail. Hopefully you can get in that program and get you quite a bit of extra gain time. There's no probation involved in this sentence, Ms. Crutchfield. When you finish this jail sentence, you'll be released with no probation. This case will be over with. Ms. Crutchfield, do you have any questions?
No, sir.
All right, Ms. Crutchfield, I wish you the best, ma'am. Mr. McDaniel, that's all I had on the first appearance list. Anything else from the public defender's office?
No, Your Honor.
Appreciate you. And Corporal, anything else from the jail this morning?
Alrighty, good morning once again, everybody. TCF Live on a Super Friday. Thank you all for joining me. If you're new to the channel, take a moment and say good morning to us in the chat so we know that you're here. We're a friendly folk. And we've been gifted 19 channel memberships this morning. If you're a new channel member, do check out your perks and benefits. One of them is the pre-show. We have a lot of fun there. But honestly, it's more than anything just a part of, you're part of the cool club. So I encourage you to consider renewing your membership once the gift lapses after 30 days. It's only $2.99 a month. It goes a long way to support the channel. And again, you kind of become a member of the inner circle, which is a lot of fun. Okie dokie, let's go back up to Michigan. Let's go to Wexford County. We'll say good morning to Judge Elmore.
Who had a vacation. Got to go out and enjoy that vacation. Our next case today is People of the State of Michigan versus Bobby Du Bois, file numbers 26-14212 FH, appearances for court.
Thank you, Your Honor. David Denhound on behalf of the people.
Good morning, Your Honor. Allison Cass on behalf of Bobby Du Bois.
All right.
Good morning, Your Honor. Lisa Kirsch-Satawa, also on behalf of Bobby Du Bois.
Before they get going, let's pause for a second. Lindsay gifts 20 memberships. Lindsay, thank you so much. Very generous of you. And TCF would not be the same without you and your presence. So thank you so much.
Thank you very much. And joining us today Ms. Satawa joins us via Zoom, and also joining us via Zoom from a Michigan Department of Correctional Facility is the defendant, Mr. Bobby Du Bois. Mr. Du Bois, are you able to see and hear the court this morning, sir?
I am.
All right, great, thank you. We're here today for a final pre-trial conference in this file. I do see that there was a motion for assistance with contact from the client. Is that still an issue today, Ms. Castle?
Yes, Your Honor. I was able to speak to Mr. Bois for about between 15 and 20 minutes this morning through the writ. We did have difficulty initiating that call through the jail. But as recently as about 10 minutes ago, I was looking at the platform for scheduling visits, and my status hasn't changed. It still reads the error that my registration has not been reviewed, and I'm not allowed to schedule visits right now. To please check back later.
And Your Honor,
Go
my
ahead.
status is the same.
All right.
I've received no fewer than 5 approval emails from the prison, so we don't know where this issue is.
Okay. So let's go through a couple questions. You had some opportunity to speak. Let me take a look and see what the charges are. So within the short amount of time that you had to speak with him, were you able to discuss enough to tell me whether or not there is a resolution today?
Yes, there is not a resolution, Your Honor.
Okay.
It's my understanding will be proceeding to trial, and I'm requesting a final pre-trial just to ensure I can meet with Mr. Bois as well as file motions.
Yes, sir.
Just a few things on that, Your Honor. First of all, I'm not challenging and I have no issue. I understand and I appreciate there's been some difficulty with communicating with the defense. I certainly would encourage more writs if that be necessary. This is, I believe, the second final pretrial. I'm not opposed to an objection, but it does appear as if we're continually kicking the can. I do want to formally withdraw any plea offers that the people have previously extended. It does appear that this is going to go to trial. My fear is that, again, I don't oppose a request to adjourn. My fear is originally we had the scheduling order in February. That gave a period of time for 30 days for motions. My fear is that this is going to be continued to be adjourned.
I'm just going to ask what the motions are and then I'll make it. First, let's take a look at what the motions are.
I have a motion to quash as well as a motion to suppress evidence. If I can.
Motion to quash.
Yes.
The bind open?
Yes.
Was there a waiver?
No, there was, the preliminary exam was held on February 13th.
Did we not get a transcript? Or do you guys have a transcript?
Yes, we have the transcript.
Oh, okay.
Might be in
There might what?
It might be in a sleeve if there are multiple transcripts.
Oh, okay. Thank you.
Just to address the delay in filing motions, well, yes, that was the initial due date. Due to these issues with communicating with Mr. Du Bois, our last opportunity to have non-recorded communications was on January 23rd, prior to the preliminary exam.
Okay. Well, a motion to quash would be only based upon the information presented at the prelim. Which would be, when was the transcript produced?
Let me look at that.
Your Honor, I have a stamped copy that our office received at March the 6th.
How come you haven't filed that in the last 2 months, 3 months? You don't need to speak to him. It's all the motion to bosh a bind over is only based upon the information presented at the trial or the prelim.
Yeah,
You don't need him.
I have no explanation as to that. No, we were just
All right.
waiting to speak with Mr. Du Bois
Well,
about motions.
that's denied. All right. Unless you ask me, then you need to file a motion to explain why you failed to file the motion timely. So what's the next one?
The other would be a motion to suppress the evidence, the needle, which was obtained.
Why hasn't that been done in the last 3 months?
To speak with Mr. Du Bois. Also, we didn't receive the actual test results of the needle until I can look into and receive that, but it was, I believe, just prior to the last boundary trial.
You got a week to file those and get them burned. There you go.
Understood. Thank you.
Thank you. When I said those, I mean the motion to suppress, not the other one. You missed the bind over because you didn't file it in time and you've had the transcript for multiple months. So there goes that one. And the motion to suppress, that's a constitutional issue. I'll let that one be preserved. You have to have the motion filed and heard by next week because the case will go to trial. Now, I will send an order that you draft an order that says the prison must allow unrecorded communication. And I'll put in there, if you want to put in there a period of time that you think is appropriate, whether it's an hour or 2 hours, I'll put that in there. And then in the bottom, I'll tell you, we'll ask you to prepare an order that says their failure to cooperate will result in the court ordering the warden to this court physically. All right. I understand they probably have some difficulties, but I do not care. The Department of Corrections will bring the warden here in this courtroom, not via Zoom. You can put that in there too. The court will not accept a Zoom appearance.
Understood.
All right. I do not like it when a jail or prison is not helping the defendant speak with his counsel. That is 100% unacceptable. I can't even fathom why they're not doing it. So the answer is we'll get it done. And if I have to issue a writ to bring him here and put him in our jail for days, I'll make sure that happens too. And we need to have that. You prepare that today. I don't care if you handwrite it. type and have somebody print it out here, but that's 100% unacceptable. All right. Anything else, Mr. Denham?
No, I believe the court has covered the issue.
All right, thank you very much. Anything else, Ms. Castle?
No, Your Honor.
All right, this case is at the top for proceeding to trial. And what's the trial date, Madam Clerk? Yeah, hold on just a second. Let me get the trial date first, then I'll turn to you. Yes,
June 23rd.
all right. Yes, ma'am, Ms. Satala?
I'm having major ankle surgery on Friday, June 12th, which is next Friday. So I was just going to ask you if you could put out the trial date beyond that. And also Mr. Du Bois is raising his hand, so I think he may have a question.
I'll get to him in just a second.
Okay.
Who's the other attorney from your office?
Lynn Getz.
Ms. Getz, I believe, is available. I can confirm right now for you, Your Honor, if you just give me 1 second. It was June, what was the date? 23rd?
23rd.
I have Lynn's calendar, actually.
All right, no problem. All right, it's gonna go on June 23rd. We kicked the can long enough. Now, Mr. Du Bois, you have your hand raised, either that or you're scratching your head.
No, yes, Your Honor, for the sake of the court and time, this has been drug out for months and months and months. If he's extending the offer for a possession right now, I'm gonna accept, and we're just gonna move forward. I want to put this to rest. I want some peace in my life. This has went on long enough. Like, if that is the case, I'll accept and we'll just move forward with sentencing. Like, this has been super taxing on me emotionally, physically. I'm already in prison, like, for the sake of the cost for the court and the time and the energy. Like, I think there's time better well spent, if I'm just being honest with you. I'll just accept it and we can move forward.
Hold on just a moment. We need to turn back to two other people here. The first one is the prosecutor. Now, hold on, before I do, let me ask you, is anybody
sir.
scored to just a simple possession?
One time.
I'm gonna guess, Mr. Du Bois, you're currently in prison, and what are you in prison on?
It's a parole violation for a domestic violence from 4 years ago. Almost 5 years ago.
All right, with a HAB 4, I'm going to assume he scores a 5 to 23, maybe a 10 to 23.
That's what I'm seeing is 10 to 23. I was just
Just
verifying.
based upon experience.
That sounds like in the ballpark.
Does anybody know how long a parole violation is on?
The Otis currently, originally was dated in April. It's because of the violations, it's been moved to July something. I don't know if it's going to be extended further, but that's what Otis says today.
And this morning, Mr. Boyes advised that he believes he has about 10 months remaining, so it's an influx.
Your Honor, looking at the scoring, I just wanted to clear. It looks like I did a score at one point, and just because of the extensive prior record, it is somewhat higher.
Just tell me what you think.
I have it at 19 to 38.
All right, well, okay. All right, so I'm not going to, I can let counsel speak to their client. Before we even do that, the first question comes to Mr. Denham. Mr. Denham, I guess that's an offer to reopen it. And technically, it's up to you now.
Well, that coming in today, that was my bottom line. We've had some discussions. I was under there saying the defendant was not going to accept it, but if he were to make the plea today, I would allow that to go forward. I would extend that today if he accepts today.
I mean, if we can get if I can get the guidelines nailed down today and we can come to some.
I got it, everybody. I know what we're going to do. At least I know what I think we should do. We're to take about, right now it's at 10 o'clock, or wait, quarter to 10. We're going to, Mr. Du Bois, if anybody from the prison comes and gets you, you tell them no, that some really mean, but handsome and charismatic judge in Cadillac says you need to stay there for another 30 minutes. We're going to see if we can go contact you two. You can call in, by the way. In fact, do that, Ms. Gansel. Call in so that way he's occupied. Right, call into our Zoom. We'll put you into a breakout room. Meanwhile, Mr. Denhoughton, do you have anything else going on over in Lake City today, this morning?
This afternoon arraignments, but nothing further.
Nothing this morning? All right, we'll chill out.
Your
We'll
Honor,
be, all right.
Your Honor,
Yes, you may.
may I ask Mr. Dent, will you consider a use for the syringe, please?
Hold on. I can't keep doing this with this one case. We're gonna take Ms. Castle and or Ms. Sotelo can be placed into a breakout room. You can talk to them. Mr. Denhoughton's not gonna go anywhere. He's gonna sit over here and watch us today, or maybe get a cup of coffee. I don't know. And then, do I have any Department of Corrections people here? I do not. Don't worry. I will ask my staff, because they'll respond quicker to us. What was his last guidelines for him? Like his PRVs? Anybody know that?
I believe he might have maxed them out.
Yeah,
I'm sure he did.
And not to belabor, but I think that the scoring that I just indicated, that was based upon a plea to resisting obstructing, which has been removed. So I think it's a little bit lower than what I just indicated.
Okay. All right. Because on a maxed out, and on one of these possessions on a D grid, everyone here in court, welcome to watching a sausage making. What we do. All right. Yeah, he's gonna max out on a 10 to 23. It could be a 19 to 38 if he has 10 points or more. And the only other points that he would be scoring would be for the OV, whether or not he scores for 12 or 13, 12. Or that assault resist. What does that give him? 1 point. And then whether or not there's anything for OV 13. As long as he doesn't score more than 9 points, it's a 10 to 23. You guys think about it. We're gonna call you back in a little bit. Ms. Sotelo, you can be put into the breakout room too, along with Ms. Castle. And we'll call the case back, Mr. Du Bois. Thank you all very much. And then you all decide what you want me to do.
Alrighty, friends, I will keep an eye out to see if they call that back. Hour 2 of TCF Live on the Super Friday. Ostrich, thank you for the $19.99 Super Chat. Order in the court, please. Well, I can't control the courts, and it's also Super Friday, so I can't control the chat either. Let disorder reign. Okie dokie, let's go to Texas. See what's going on with Judge Stevens.
Habitation?
Correct.
Ready?
Yeah.
Ashley?
Yes. Yes. And so
Wait, she didn't have the same last name as you. Is that right?
Yes.
But y'all are married?
Yes.
How does that work?
She kept forgetting.
Y'all have different surnames?
Yes.
But y'all are married?
Yes.
Okay. Is that unusual, or am I the only one on the planet that lives a conventional lifestyle? Like, my wife keeps her maiden name, but it's the male's surname. But these are two different names. That's what throws me off.
But I spoke
Are
with.
y'all ceremonially married?
Yes, sir. You got married in Las Vegas.
In Las Vegas?
Yes.
Well, that's legal. It's more interesting. Get married there. But okay, that's one way to do it. But there's going to be confusion, at least, when the two names are used, and then one says, I'm married to him, but we have different last names. That hadn't been a problem at all in your existence? No. Okay, good luck. Well, you can do that. It throws somebody like me off.
Right.
Okay,
I spoke with CPS. I spoke with the CPS officer in charge of the case at the time, and she was in agreement with my recommendation, which was that the defendant should not be allowed to have contact with his wife until after he completes the BIP program. He is currently enrolled in the program.
where are you in that program as far as how far along?
He is almost 2 months in, and I have his progress.
What does that mean? What is the?
About a third of the way through, Judge.
Correct.
Okay, so half a year.
He has attended 9 of 9 sessions so far.
Okay.
I do have his progress reports here. There has been no issues. He's participating. He's doing well. He's paying, he's attending, he's had no absences. So I am in agreement with her recommendation. She is in agreement with my recommendation that he should complete BIP first, and then he would be allowed to have contact with the victim.
Okay, we'll take it up after the BIP Matters Intervention Protection Program is completed. You are here on a burglary of a habitation, right?
Yes.
And in 2013, you were convicted of a burglary of a habitation out of Harris County, correct?
Yes.
Was it the same victim?
No.
Different person, similar facts,
Of
ironically.
interest?
Yes, sir. And it was only because of the victim's impact input that I agreed to a probation on this case. But I also made it a condition at the time of that plea that I wasn't going to agree to contact. And all they've done since the probation started is come back and ask for contact.
All right. Let me go back to 2013 on the burglary of a habitation. The victim in that case, was that a romantic interest of yours?
Oh, yes, sir. That's my son's name.
Do you see some kind of a connection here?
Yes, sir.
You burglarized the people you claim you love.
Yes, sir. I was living there at the time, and when we split up, we were living together. We were high school sweethearts. She moved. The situation that happened, and I let myself into the home. This situation here.
No, you burglarized. It's burglary. You were convicted of burglary.
Yes, sir.
Which is entering without permission, breaking. You forced your way somehow
Yes,
into it, which is what we're doing here again.
Yes.
It's as though we didn't learn our lesson the first time. But I went with this on this disposition.
I'm still living in the home, in my home, in the home now. I'm still living in the home.
Where's the lady? That
She's separated. We separated as from
Okay.
court date.
Well, we're going to continue the order that was placed at the beginning, and let me just read some real quick. Okay. Discussion. Oh, see what. What we have here is a consistency problem that bothers me. But in each of these cases, you were convicted, and in this one, you're convicted. You were placed on regular probation, but you got a conviction, a second conviction, which means the next felony, you're looking at 25 to life, a habitual felon. Each of these similarly state that you committed burglary with intent to commit assault on the victims. And I'm looking at the probable cause affidavit, which is in this one. I don't have it in the first one, but this one's bad enough to read. And I remember this was very disturbing. kicked in the front door, grabbed her, threw her to the ground, assaulted her with a closed fist. You punched her with a closed fist. Let's see. Injuries were seen to her face, right knee. Then you fled the scene, which was about the most unmanly thing to do, in your little black Nissan Altima. And they had to chase you, and they caught you soon enough. And then you tried to evade them. Then you were finally arrested and transported to the police, to the jail. Let me ask you this. You said you're ceremonially married to this lady? When did y'all get married?
2 days after our birthday.
What does that mean?
2 days. April 20.
Oh, like I don't know your birth date.
Right.
No.
April 24th.
Of what year?
2022.
Sir?
2019. Sorry.
Well, let me read the probable cause affidavit here. It says, police were dispatched to a place in Beaumont in reference to a burglary. The police observed damage to the front door, then made contact with the lady, Ashley, let's call her, who was in the rear bedroom. And speaking to her, police observed damage to the wall, television, bedroom door. And she advised that her ex-boyfriend, Jacoby Broussard, ex-boyfriend, y'all were married.
Yes, sir. We were.
Why is she referring to you as her ex-boyfriend?
I have no idea, sir. We're legally married, sir.
Is that a fact? Does probation?
I
I mean,
don't
this
have
probable
any,
cause that they write, just what it's told. Why would anybody, why would a married person, ceremonially married, say it's my ex-boyfriend? I mean, that's just bizarre. And listen, and she said, you grabbed her, threw her to the ground, and punched her with a closed fist. About the most unmanly thing you can do to punch out girls. It's not, those kind of people were dealt with pretty severely where I grew up. That you don't punch girls. You don't punch guys. You shouldn't be doing that. But picking on a girl is kind of weak in the character. I don't like this. Second time you've been convicted of burglarizing with assaulting behavior. So we're going to put you through some training that you should have learned when you were a child. And that is respecting others, especially people you claim you love. Or what do we need to do? Do you only have any contact with this person until I tell you? Do you have a GPS device?
Yes,
so
sir.
we know where you are?
Yes,
What kind of?
we monitor that.
Right. What else can we do?
I mean, he's in BIP right now. He is doing what we're requiring of him.
Okay,
So
anything else we need?
at this point, just, continue to have no contact with her, and then maybe we review it again at a later time once he's completed that program.
Okay, how long is it going to take?
He still has 10 sessions, which is 10 weeks. So I would say at least 3 or 4 months.
Okay, we're going to review it in 3 months. All right, get a resetting. And these are 2 cases here, not only the burglary, but the evading arrest that he was pleaded to. Chaston Bryson John?
It was set for a hearing.
For evidence hearing, for you to make a decision, but I haven't.
On a motion to revoke probation, you mean?
Yes.
Okay, so when can we do that?
I'm actually missing my detective that I need
Yeah,
for this judge.
Let's
So
set
can we
it
have
for
a
some,
reset?
okay,
Yeah,
so
that's fine with me, whatever date y'all want to set it for, I'll give you available.
1 week?
Yes.
The 12th of November, Judge.
Friday, it's the state farm,
Oh,
and then it's the holiday, the 19th.
you know, for
2 weeks.
Whatever works for you.
Let's go for 2 weeks on a Friday. Can we do that?
Yeah.
What did she say?
It would be 3 weeks because 2 weeks is the holiday. So then you would want the next week.
Whatever works, I'm good for that.
Okay, 3 weeks and then we'll get something hopefully done. Whitney Beck. Whitney Beck, where's Whitney Beck? Is she in custody?
She's running late. She did call. Be here at say,
Eden Jones, please. Hello. Do you have an attorney? And this is a motion to revoke probation pending, right?
Yes.
Well, you don't have an attorney? I mean, let's see, this is costs and arrearages and restitution. Well, I mean, here's the deal is that it's a second degree felony of aggravated assault. You were sentenced to 2 years, probably for 5 years. How did that happen?
That's on.
Hold on for just a second. I'm asking a rhetorical question on this one.
Yes,
How
sir.
did that happen? How did she get a regular probation on an aggravated assault with a deadly weapon? I didn't think we could do that.
Well, we have additional problems in that regard.
Yeah.
Maybe you want to read my notes there and I'll share all that on YouTube. If you can read my handwriting.
All right, well, get me,
I'm gonna take care of that. I'm sorry, I didn't see that till just now.
all right. Okay, we're gonna, this estate's looking into something, ma'am, and we're gonna hold this in abeyance here. I want you back, next week, Wednesday. On a Wednesday for a review of where we stand on this. Okay.
It's either Tuesday or Thursday, when for it's for integrate pictures. I don't have to put that.
Tuesday, yes, Tuesday, okay. Thank you today.
Man, the young man.
He's what?
He has, we suspended his, 180-day weekend jail, so he's gonna work in the instead.
Yeah, okay, what is this, what is the status?
He's doing very well. He is working, he's paying all fees, he's doing his, he's working on his GED class and he can.
Where are you in that?
I downloaded an app on my phone because I couldn't.
Where are you in it?
Uh,
Have you begun it yet?
I have a little bit. I have to build it on. It shows me a video on it and then it makes me take pop quiz on.
And then you get your GED? There's gotta be more,
Uh,
there's gotta be more than that. I mean, it's a high school equivalency, which means 12 grades are thrown into that process. And generally it occurs over a period of time that's longer than 10 or 15 minutes.
I called the Texas workforce place and as I was going right there to take my class and they gave me a phone number to call. I've been calling, but the person that I'm supposed to be calling hasn't answered.
Okay, so the burden is on you to work to get it done.
So
Okay. There's nothing wrong with an education. It's maybe the most important and meaningful thing you can really do in life because it helps you make better decisions and keeps you out of this courtroom on cases like aggravated robbery. Okay, what do we want to do to that?
You continue him, just let him continue to work and be productive. And if he
violates in any way, is he not compliance?
Okay, do we need to set this for a review or anything like that? Because I'm curious about where he's going in his education. You know, that's what I want to know about.
If he falls off in compliance, Your Honor.
Okay, that's important. That opens doors of opportunity. You gave me this document. Do you want to put this in the file?
I want to.
Yeah, I'll scan it in.
Man,
Yes, sir. One in the file, please, just so we.
No.
This-
okay. Good luck. Keep doing good things. Jessica Moya, please. Is she here? Jessica Moya, no answer. I asked the bailiff to call into the hall for Jessica Moya. Actually, it's Mota Para. Did you see her out there by any chance?
I'm not sure.
Well, just covering it, stop it on the first one.
That's a way to do it, but you have the left hand and the right hand direction. These look like, yeah, community service, money, tons of restitution. Come forward. You're Jessica Mota?
Yes.
You've been on probation here since February 4th of 13 years ago.
Yes.
And this is all about really money, right?
Yes, sir.
There's something about performing community service hours, but I'm more concerned about the restitution of $30,000+ to the victims that are still to be paid.
I see some notes from the prior hearing judge that you waived the remaining community service hours to have her focus on restitution.
Is that what everybody shows?
Yes, sir.
Okay, then why do we, okay, this was a motion to revoke probation that was filed 3 years ago. So I don't see anything on it that we that I wrote on, but I don't have a problem with the community service hours. I just want you to work to pay the people back the loss. The restitution was ordered in the amount of $53,485 originally, and that was 13 years ago. And so what's the balance today?
The balance today is $16,677, with her last payment being on May 29th in the amount of $520.
Okay, 16,000.
$677, yes, sir.
Right. How much out of this whole amount how much have you paid toward this restitution over time now?
I paid.
About $40,000.
Mhm.
All right, I'm pleased. Keep up the good work.
Yes, sir.
Okay. We'll all celebrate when all this is done, but this is important. Not only the victim, but this is for the court and for you as well. You were placed on deferred or unadjudicated probation, which means at the end, you do well. The case is dismissed
Yes, sir.
without a conviction.
Yes, sir.
Okay. Where are you working?
I work for Dr. Bart.
Okay. And how much money are you able to pay a month on this restitution?
Paying $520 a month.
You are?
Yes, sir.
Okay. So in 12 months, what is that? 62,000, which would more than pay this. 6,000, I mean, which would go well toward almost paying that off.
Mhm.
So,
That's the goal.
all right, we review when? 6 months?
6 months.
Okay, maybe we can celebrate.
Yes, sir.
All right, thank
Thank
you.
you.
Please get a reset. Yes, ma'am. Jay Nelson?
Just.
Jay Nelson? No answer in the courtroom. I asked the bailiff to call into the hall for Jay
Yeah, I get you.
Nelson, please.
Yeah.
This was,
It's a safety review. This is from probation.
there's no response to, the name called here in the courtroom, no response to that name called into the hall. Defendant has failed to appear. There was a resetting ordered for, today and for review of status, and the defendant has failed to appear. What can probation tell me about things? I'm looking at an administrative hearing memo that was dated May 28th, a week ago or so, and it's not looking good. And failed to report to probation.
Yes, sir.
Failed to submit the alcohol drug screenings. Oh,
He completed the entire safety continuum and stopped reporting. I've talked to him once. I tried to call him today. He doesn't answer text messages, letters, or.
well, that's his obligation, not for you to go find him, but for him to report his direct. I am signing this order, ordering a motion to revoke probation to be filed, and then we'll deal with it. When, yep, we'll order a motion. Thank you for trying to help this guy, but sometimes people work against themselves.
Alrighty, friends, good morning once again. TCF Live on a Super Friday. I hope you're all enjoying this morning. I know I am. Let's go back up to Michigan, checking on Judge Middleton. He's still going strong up there.
Good morning, Ms. Green.
Good morning.
Apologize for having you back in that little cage back there.
Yes, it was a bit warm.
Yes, it's not good. They've got you listed as Carrie. Candle fire. And you've got 7 days. You have a total of 7 days of jail credit. 2 at the front end, 1 when you missed another court date and I let you out, and then you've been in jail for 7 days here. So that's a total of 10 days. The last case we did was through an interpreter, and we had to be very patient. Let's talk about your case. It'll be a lot easier. You're charged with larceny in a building, originally a felony, and they dismissed that charge and charge you with a misdemeanor charge of larceny under $200. Excuse me, over 200, but less than 1,000. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. The prosecutor has agreed to dismiss that charge if you plead to disturbing the peace or disorderly, I guess we'll call it disturbing the peace. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $500. They're also going to recommend that I give you time served. And that would be 10 days plus the minimum allowable fine. Do you understand that?
I do.
Did anybody threaten you to get you to plead to that charge
No.
or promise you anything? Do you understand that if you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or a jury? Do you understand?
Yes.
If you had a trial, you'd have the right to be represented by a lawyer. Everybody just heard this. We'll give it to you again. Ms. Harden has been appointed to represent you. You'd also hire an attorney of your own choosing if you wished. If you had a trial, you'd have the right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
I do.
Were you in the store in Three Rivers? Let me see where this was.
Triple Creek.
Triple Creek on South Main Street. And did you take somebody's phone?
It was in the bag I took that was in the store with me.
All right, that wasn't your phone.
No.
And then the guy chased you and tried to get his phone back?
Yes,
Eventually, did he get his phone back?
he did.
All right. All right, you've been in jail for a total of 10 days. 10 days credit, 10 days. I'm gonna waive the fine. I'm gonna waive the attorney fee. I am gonna order the state minimum fee of $125. Where are you gonna go when you get out?
I plan on trying to see, if Keystone has any availability,
They
so I
do,
can get a job and get back on my feet.
all right, $125 or 2 additional days. Somebody will bring you $125, you can get out. Otherwise, you may end up there for till tomorrow.
If you need to send me mail, right now I have a hold on my mail, for a specific address, so I can pick it up at the post office.
All right. Well, you can go with the officers. They can take everybody back, Mr. Swinehart and whoever else is in there. Ms. Green, good luck to you. All right, we had to deal with the in custodies. We have a very bad situation here at this building for in custody defendants. But let's do Mr. Smith and get him out of here. Good morning. Who's your client?
Mr. Hagan,
Jason Hagan, file number 26782ST. Mr. Hagan, you're charged with reckless driving. There's apparently no plea offer. You simply asked that the matter be set for a final pretrial.
correct, sir.
Reckless driving is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. I told you this at your arraignment. It also requires that your license be suspended, which might be the hang up here. Also absolutely kills your car insurance. You were going 115 miles an hour at a very terrible spot. 131 and William R. Monroe Boulevard. So the prosecutor isn't willing to budge on this apparently. We'll set it for a final pretrial, which will be on a Thursday afternoon. And we'll work that out on a date that works for Mr. Smith and for you. I don't find that you owe us any money. So that's a plus. Do you still live on County Road 2, Bristol?
Yes.
All right. I'm interested to know more about this. As I said, that's a real bad place to go 115 miles an hour, either whether you're headed northbound or southbound. But we'll explore this further at a final pretrial. It'll be set several weeks from now on a Thursday afternoon. Thank you. You're good to go.
Thank you very much.
All right, let's clear out a couple other people who aren't bleeding. Mr. Guthrie, would you come forward, please? This is file 252538ST, Justin Guthrie. Mr. Guthrie's. All right, I'm sorry. This is file 252538ST, Justin Guthrie driving suspended. That occurred back in allegedly October of 25. You're also charged with domestic assault and cruelty to animals. And that occurred in April of 26. That is file number 26605SM. You're here with your lawyer, Mr. John Bush. In this case, Mr. Bush, he's asking for a last pretrial in each case.
In both files, Your Honor.
All right, Mr. Guthrie, those will both be set on a Thursday in the next couple of weeks. There's a no contact provision in here between you and Rachel Guthrie. At least I think there is. Let's find out. She looks surprised, you look surprised. You're sitting there next to each other, so maybe they didn't put a no contact. I don't see that there is a no contact provision in here.
There wasn't one prior, sir.
Say that again?
There wasn't one previously or prior to that.
I don't even see.
Asked that same question the last time.
I did. I don't even see the bond form. All right. I'll set this for a pretrial on June or on a day to be set. I don't yet know what it is. You're free to go.
For which day, sir?
I will tell you when.
Oh,
You're good to go. We'll give you notice of your
He
next
doesn't,
I have a
day.
hard time.
he doesn't hear real well, Your Honor.
I know that. I've known him since he was in 8th grade. So, you're free to go. And, we will, set this for a pretrial on a Thursday afternoon. I don't want any more trouble between you and Rachel, or I don't want you driving till we get this sorted out. You understand?
Yes, sir.
All right, you're good to go. Brandon Bryant. Good morning, sir. Are you Brandon Bryant?
Yes.
You're here with your lawyer, Mr. Robert LeBray. The prosecutor has agreed to dismiss this charge, as I understand it. Says dismiss on motion of the prosecution. You have posted that's a PR bond. Oh, I mean, look, looks like there's money in here. Is that your understanding, Mr. LeBray?
Yes, Your Honor. At least regarding the dismissal.
Turned himself in. The bond is a PR bond. I don't have any money to return to you. The matter is dismissed on motion of the prosecution. You're free to go on about your business. Mr. LeBray, nice to see you. Sorry I didn't get a chance to talk more.
Always a pleasure. Hope you have a good day.
And then I've got lots of cases to take pleas on.
Your Honor, I do have several no-shows.
Yeah, I see that. Let's talk about a couple of them. Billy Kelly. Oh, that's John's no-show. Billy Kelly has two files, 26471SM and 26169SM. It appears he's failed to appear in each case. He owes $748 worth of other unpaid fines. Mr. Bush, you have any contact with the defendant? Do a bench warrant, $500 cash or surety in each case, 48-hour hold. Mr. Kelly is local. I don't think he's gone anywhere. He owes $748 in unpaid fine and costs. Thank you, Mr. Bush. Let's talk about Angela Lowry. This is file 26412SM. Angela Lowry is charged with malicious use of a telecommunication device. She posted a $2,000 PR bond. She is not here. She has two open warrants for her arrest: malicious destruction of property and resisting and obstructing, file 26825FY, and 3 counts of resisting and obstructing. These are all on May 3rd in file 26824FY. And did you ever have any contact with this defendant?
No, Your Honor, she was scheduled for a PCC on those felony matters on May 19th, and she did not appear. My contact with Community Corrections regarding Ms. Lowry was that there was a mental health case open on her. I don't have that file number, but that could contribute to why I've not heard from her. She's not been appearing, but I've yet to have contact with her since being appointed early May.
Is there a reason to believe that she's in a facility somewhere?
I couldn't even begin to tell you because I'm not sure how much information I'd be able to get on an MI case.
Well, she isn't here. I'm gonna do a bench warrant. $2,000 cash or surety, no 48-hour hold. She already has 2 open warrants. Thank you. Timothy Kracher.
Okie dokie, friends, let us move along. We're going to head north to the greater Lansing Metroplex. Say good morning to Judge Aquilina.
I'm gonna change every word of victim to this. Oh, okay. And. Okay. Mine.
I just have to wait for the court reporter.
And is
this, Mr. Peterson?
Mr. Wickwire, Your Honor.
Okay.
Thank you.
This is actually private. Private hearing, Your Honor.
Oh, yes, first. Gotcha.
Your Honor, can we approach?
You may.
Yeah. Or 7.1.
So,
7.1.
7.11. My knowledge.
Oh, check.
It's on the schedule. Was he eligible for 74?
I might be mistaken, but mine is.
Yeah, no, Mr. Wickwire, prior drug convictions, Your Honor. I don't believe he was.
I don't think there's 74.
I apologize, Your Honor.
It's okay, because he had a have as far as I remember.
Yes.
So I don't think.
Never mind, Your Honor.
Okay. no
For whatever
problem.
reason, it wasn't on.
It's okay.
Yeah.
That was last minute. Yep.
30 seconds. This is for the, with wire. With wire. Everybody ready?
Okay.
This is docket 24806 FH. People of the state of Michigan versus Randy Lee Wickwire. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bar Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Jacob Starks, the 4th Assistant Public Defender, here on behalf of Mr. Wickwire. He's president of podium. He's standing to my right.
Good morning, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, ever telling perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, you plead guilty to controlled substance possession of controlled substance known as methamphetamine, punishment by 10 years. You were placed on probation. I now have a probation violation. Have you reviewed it with your client?
We have, Your Honor.
And the probation agent is here, Dan Brown?
Yes, Your Honor.
All right, and are there any amendments?
No, yes, Your Honor. There is an amendment to count 2. It should state that anytime thereafter he failed to report to probation.
Any objection?
That's been disclosed, Your Honor. I've had an opportunity to discuss it with Mr. Wickwire. The amendment would change the count from a technical violation to a non-technical violation of absconding. Mr. Wickwire has been advised of this, and you understand what that change would be, correct, sir?
Yes, sir.
Yes. Thank you.
Thank you. Sir, have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
All right. And you're going through any kind of withdrawal?
No.
All right, very good. Sir, I have allegations as follows. Count 1, on or about August 13, 2025 and August 18, 2025, you failed to complete a drug test at Abigail. Count 2, on or about August 19th, 2025, defendant failed to report to probation at any time thereafter. I had put you on a probation term of 24 months appears, and that had not yet run. And are you waiving further arraignment?
We do, Your Honor.
Will this
Thank
be a
you.
plea or a hearing?
It will be a plea, correct, Mr. Whitmire? Yes, ma'am. Thank you.
All right, sir, as to count one, well, let me just ask you this first. Are you pleading of your own free will?
Yes, ma'am.
And you discussed all of this with your attorney?
Yes, ma'am.
And no one forced, threatened, or coerced you to plead?
No, ma'am.
And you've been satisfied with the representation of your attorney?
Yes, ma'am.
As to count one, on or about August 13 and August 18, 2025, failure to complete drug testing at Abigail, how do you plead?
Guilty.
As to count two, on or about August 19, 2025, failure to report to probation and any time thereafter, how do you plead?
Guilty.
Sir, you understood the terms and conditions of probation. You were to complete any treatment, testing, and show up to probation regularly as requested, and you failed to do those things. Is all of that correct?
Yes, ma'am.
Did anything happen to you where you were hospitalized or something happened where you couldn't comply with the terms?
At the time, ma'am, I lost my place of stay and my phone got stolen and it took me about a month to get a new phone.
Okay, but still you didn't call,
Yeah,
you
you're
didn't
right.
walk here, didn't get a ride, you
You're-
didn't borrow a phone.
You're correct.
Okay, appreciate you saying that. A lot of times people give me a whole list of excuses, so
Nope.
you understand that.
Yep.
And probation could have even helped you with those things.
And probation what?
Could have even helped you with those things or work out those things. That's what this, probation's not a punishment. It's actually meant to help you get better, but you gotta do the work.
Yes, ma'am.
All right. I find by preponderance of the evidence and his own admission that defendant has violated probation. Count 1 and 2 will enter. May we go into immediate sentencing?
Yes, please, Your Honor.
What is the recommendation from probation?
Thank you, Your Honor. At this time, Mr. Whitwire was doing very well. When he was released in May of 2025, we had many conversations about probation and how probation could help him. He was testing 3 times a week. Once he was released from the jail, all negative. He had not missed a test, and he was engaged with peer recovery through Michigan Department of Corrections and Community Mental Health. He also was referred by myself to go to LCC for their modern warehouse free training job opportunity, which he was engaged in that. So it was kind of surprising that he just didn't or stopped showing up to probation. However, at this time, probation is willing to continue to work with Mr. Whitwire if he would like the help. He has served 311 days jail total on this docket. So probation would recommend that he be served the 311, be released, and continue probation.
Does that include the 77 initial days plus the new days?
Correct. He was in custody from 7/24 to 5/7 of 2025, and then 14 days on this bench warrant.
Thank you. On behalf of the people, what would you like me to know?
Your Honor, the people would agree with probation.
Thank you, Your Honor. On behalf of Mr. Wickwire is very sorry he stopped reporting. He just ran into a real rough stretch after he got out of jail. He lost his housing, he lost his employment, and he lost his phone. And he regrets not reporting back to probation once he got a phone, Your Honor. But to his credit, he's been maintaining his sobriety. To his credit, Your Honor, he would raise another opportunity to successfully complete probation if Your Honor believes that's the appropriate sanction here. And he's trying, Your Honor. He's trying really hard. He's just run into some personal challenges on the outside, Your Honor. But he understands the importance of maintaining his sobriety, and he would like to explore opportunities to see if he might be eligible for additional housing options, maybe support that way. And then he will certainly pursue employment if he gets released and make sure that he complies with all of Your Honor's orders if Your Honor grants him another opportunity at probation. Thank you.
Sir, what would you like me to know?
I don't think there's anything for me to say that you don't already know. I mean, I would love it. I would love it on another opportunity. I would. But that's gonna be all up to you.
Well, I know that, but tell me, are you committed to your sobriety?
I am. I've been sober. The staying sober hasn't been the problem. It was the housing situation and when my phone got stolen. And when I just didn't know what to do after I got the new phone and everything.
Okay, part of your rehabilitation is, I need help. You need to ask for help.
I'm not,
Yeah, I
that's
know.
something I've never been good at doing.
Well, when you learn that lesson, your problems, your load will be lighter. There's lots of people in this community who will help you. First and foremost, probation. They can help you unlock doors that you don't know are available to you. And there are some new homeless shelters that have opened that are brand new and could give you a bed temporarily till we find a place for you, or you find a place, you get a job. There's lots of help in this community. You first have to say, I need help. That is not a sign of weakness. You're in the majority. Most men think that if I ask for help, I'm weak. But you know what? Flip that script in your head. Asking for help is a sign of strength.
Okay.
Does that make sense to you, sir?
Yes, ma'am.
Because all you do is bring yourself down and you don't ask for help. You get picked up by law enforcement, you sit in jail, you're in that jumpsuit.
Yeah.
You get in front of me, that can't be fun, right?
No, ma'am. Sure ain't.
So tell me about work and options. Were you getting to the point of holding a job or getting trained? What?
Well, I did attend the class, like she said. I went through it, I got all the certificates for it, and it was like right after that class happened is when all this situation happened. So I knew I had the warrants and I couldn't really progress any further with it. But I do have every single week, the Michigan Works Office, they've been sending me information for jobs. So
Where are they sending it to if you're homeless?
my email.
Okay, so you have your phone back?
I have a new phone, yes, which I have a new phone number, which I would have to give to Ms. Brown.
Okay, so you get 365 days credit for 311 balance held. Here's what you're going to do, sir. You are going to get real. Because otherwise you could go to prison.
Yes, ma'am.
If you want to get trade school and all the things you ought to be doing done behind bars, happy to do that. It's up to you. Your choice, your decision. Free man or imprisoned man. You're almost out of jail time.
Yes, ma'am.
So today's lesson is I will ask for help.
Yes, ma'am. I'll ask for help.
Good. Because essentially what you've done by not following the orders of this court is ask for help. You're saying, extend me, I need help. If you would have just asked sooner, we wouldn't be here. Does that track with you?
Yes, ma'am.
Okay, so you need to provide your phone number to probation.
Okay.
And every address within 24 hours, address change. Do you have a place to go to, or are you going to be in the shelter for now?
I'll have to be in a shelter for now.
Okay. I don't think we need to amend any orders. He needs to be re-engaged with whatever employment skill programs we have. And he needs to apply for some kind of temporary housing. I don't know what the options are, but we need to work with him on that. Is there anything else that you need that we're not addressing, or you?
Not this time that I could think of.
Okay. So you'll probably be released today. I don't know if probation will still be here. Can you come back here on Monday?
Yes, ma'am.
Does that work with your schedule?
Yes, Your Honor.
Okay. We're gonna get you back on track, testing, doing all the things you're supposed to do. Ask for help.
Yes, ma'am. Thank you.
If there's any additional treatment, let's get them there, or any additional education for employment, let's do that.
Yes, Your Honor.
I look forward to signing your discharge successfully from probation and you getting on track with your life. The only one that can put it on track is you. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
Lessons in Judge Aquilina's court today brought to you by the letter H. So, hour 3 of TCF Live. Good to have you all here. Dungeon Court is up and running today, so at the bottom of the hour at some point we will go to Dungeon Court. For those of you who are new here, stick around. Dungeon Court is our Friday guilty pleasure. Let's stick with Judge Aquilina. I think she's got another contestant coming up.
Your Honor, may I approach?
You may. Okay, is this my copy? Yes.
Right, can we get a hearing device?
Yeah.
Harrison, please. So they can.
Are you ready, counsel?
Yes, Your Honor.
And they're
Thank you.
getting a listening device for him, so.
Oh, do we need, oh. wait.
Yeah.
Okay.
Was this working for you earlier, Mr. Freeman? That was working for me.
Just the headphones, maybe?
Well, we should have 4 steps.
We have 3.
Someone took one of ours then. Well, they all work.
I bet they'll.
Maybe. Hello?
But Mr. Freeman's Mr. Freeman.
Hello? Can you hear it?
I'll go reset it real quick. Because Mr. Freeman's was working earlier and it's not working now. Give me like 30 seconds, I'll go reset it.
So why do I linger on moments like this sometimes rather than jumping to other courts? Because this is real life. Court doesn't always work like you see on Law and Order, where the script demands that it moves along at a mighty pace and people are tried and convicted in like under an hour. This is how court sometimes goes. It's real life, my friends.
Is it working?
This one is not, but this one is.
Is it too
Oh, God. That one's working, Judge.
Can you hear now, sir?
Yes.
Thank you.
Can you hear me, sir?
Yes, ma'am.
All right, very good. This is docket 24-651FH, People of the State of Michigan versus William Benjamin Peterson. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan with probation.
Agent Michael Province on behalf of Agent Stephen Green for probation.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender, here on behalf of Mr. Peterson. Mr. Peterson is present at the podium. He's standing to my right.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the comes of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, you pled guilty to count 1, controlled substance, possession of a controlled substance known as methamphetamine, punishable by 10 years. You were placed on probation. You recall that?
Yes, ma'am.
And you were placed on probation for 24 months with certain conditions. I now have allegations, 3 counts. There's an amended probation violation. Counsel, you've gone over those?
We have, Your Honor.
Sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And sir, I have 3 allegations. Count 1, on or about October 22nd, 2025, defendant failed to enroll in complete opiate methamphetamine specifics, the OMS program at TRICAP. Count 2, on or about May 22nd, 2026, defendant was in possession of methamphetamine. Count 3, on or about October 22nd, 2025, defendant failed to report to probation or any time thereafter. Are those the allegations that you reviewed with your client?
Yes, Your Honor. We received an amended information this morning, but I have had the opportunity to explain what the amendments are to Mr. Peterson this morning, and we had anticipated this after conversations with his probation officer. Thank you.
And are you waiving further arraignment?
We do, Your Honor. Thank you.
Sir, do you understand the 3 allegations?
Yes, ma'am.
And is it your intention to plead to those?
Yes, ma'am.
And you're doing so of your own free will?
Yes, ma'am.
No one forced, threatened, or coerced you?
No, ma'am.
Your Honor, I would note this is going to be a plea to count 1 and to count the added amended count of absconding on 10/22/2025. As it relates to count 2, Your Honor, that depiction, the allegations of possession, Mr. Peterson has a pending matter at the 54A district.
I see. Is that?
That is correct, Your Honor, and it's currently set for preliminary examination on June 11th.
All right, so let me count 2. I'm simply going to strike count 2.
Thank you, Your Honor.
It's a bit redundant to have it here and then come up, so we'll deal with all of that if and when it comes up.
Thank you.
Sir, you'll be pleading to count 1 and count 3, is that correct?
Yes, ma'am.
And you're pleading of your own free will
Yes, ma'am.
after you spoke with your attorney?
Yes, ma'am.
And you was satisfied with the representation of your attorney?
Yes, ma'am.
And counsel, you also the attorney in the pending matter?
Yes, Your Honor. Myself and Vita Tessmer-Rothstein.
Thank you.
Thank you.
Sir, as to count 1, on or about October 22nd, 2025, failure to enroll and complete the OMS program, opiate methamphetamine specific program at TRICAP, how do you plead?
I'm guilty.
And as to count 3, on or about October 22nd, 2025, failure to report to probation then and any time thereafter, how do you plead?
Guilty.
Did anyone force, threaten, or coerce you to plead?
Mhm.
And sir, you understood the terms and conditions of probation?
What I've been told, I kind of heard that they're gonna turn me, that I can plead guilty to them, I can get help, I want help.
Sir, wait a minute. Can you just start over, but I'm asking if you understood the terms and conditions of probation?
Yes.
Okay, and you understood that you needed to complete any programming that I ordered?
Yes, ma'am.
And you failed to complete the OMS program?
Yes, ma'am.
And you also failed to report to probation since October 22nd, 2025?
Yes, ma'am.
All right, was there anything that prevented you, like a hospitalization?
I'll say this way,
Sir, you have to just enunciate, the court is not understanding you.
I'm sorry, I'm trying to tell you what I think I need, if that's what you're asking.
That's not what I'm asking.
Okay.
Is there anything that prevented you? Is there anything that stopped you from complying with these orders, like were you in the hospital?
No, ma'am.
All right. I find defendants pleased and freely voluntarily knowingly and understanding we may also find if there are sufficient grounds by preponderance of the evidence his own admission to enter count 1 and count 3, count 2 was dismissed. May we go to sentencing?
Yes, please, Your Honor.
What is the recommendation of probation?
Your Honor, probation recommends the defendant's probation be revoked and he be sentenced to 365 days jail in the Ingham County Jail. Credit for 73 days served. The defendant was ordered to complete TRICAP following sentencing and was being transported to TRICAP when he absconded from their van, thereby placing himself and other people in danger by fleeing outside of the vehicle in the roadway. The PSI indicated that the defendant had admitted to lying to police at his instant offense for this probation about swallowing heroin in the hopes that they would take him to the hospital so he could abscond there, but for the fact that the police did not have officials to stand with him, he would have carried through with it. And then the current police report in the pending matter in 54A also indicates that the defendant attempted the same conduct. The defendant's conduct has shown that he is not willing to comply with any type of supervision or treatment, and he does appear to need that treatment, so probation would recommend he get that treatment in custody.
Thank you, counsel.
Thank you, Your Honor. Mr. Peterson is going to be requesting another opportunity, Your Honor, to try inpatient again. Without getting into the specifics of the allegations on 5/22/2026, of course, Mr. Peterson is presumed innocent, but it's safe to say, Your Honor, that Mr. Peterson has struggled with substance use for years. He made a very poor decision when he absconded from TRICAP, and he understands that what he did was wrong there. And Your Honor, he has had some time to think and reflect on his actions. And he realizes now that he really needs the help at this point. We are attempting to negotiate a possible plea deal for him on the pending charges, Your Honor. Our goal would be to see if we might be able to work out a resolution that would potentially allow him an opportunity to pursue rehab on that file. So simultaneously with this, Your Honor, I would respectfully request that Your Honor give him another opportunity here to try rehab, whether it's inpatient or outpatient. Mr. Peterson is a skilled tradesman. He was working he can reestablish those connections in the community. He's an older gentleman. He's in his mid-50s, and he's at a crossroads in his life. The addiction, unfortunately, Your Honor, is something that he has really struggled with. So respectfully, Your Honor, I certainly understand the probation's position on this. But having Mr. Peterson just sit in jail with the limited treatment options available at Ingham County Jail, which there are treatment options available for him, and that's to the jail's credit. But respectfully, Your Honor, perhaps Mr. Peterson, if given an opportunity, and will be successful this time if he goes into Tri-Cap or Bear River or something a little more intensive, Your Honor. Thank you.
Sir, what would you like me to know?
I do got a problem with methamphetamine. I've been having problems with that. It's a really good program. I talked to a couple people, and it's like Bear River. I just hear a lot of people go to Bear River don't even want to come back here. They're doing really good there. That's why I'd like to go there and go to ride, because I never had my own house or nothing like that. I always live with people, and that's been my problem too. I don't know how to go about it. I heard ride is a good thing to go to, and I just want to better myself, for myself, and not anybody else, just for myself, so I can get back by it. I'm, like you said, I'm older. I'm 54 years old, and I'm pretty much over this going to jail, and I want to better my life, and I'm ready to do it one way or another. That's how I want it. That's what my ambition is.
Did you want something added?
Your Honor, I just wanted to state, as far as the defendant's willingness to go back to treatment, as previously stated, the police report from May indicated that he was attempting to do the same thing of absconding. As far as treatment programs, the OMSP program at Tri-Cap is the best for him, and the defendant failed to even make it to the facility to do so.
Thank you. On behalf of the people.
I would agree with probation, Your Honor, given Mr. Peterson's history. He's been to jail 7 times at this point, and it looks like he's been to prison once, based off my brief review of the PSI. This has been a drug issue that he's been dealing with for many years. We attempted to try and get him help going to Tri-Cap, and he fled it during transport. So I would agree with probation. Thank you.
Anything further on behalf of the client?
Nothing further, Your Honor. Thank you.
Sir, it looks like from your own admission in the pre-sentence investigation report, you have one real job. The rest, you just do odd jobs to probably get your next fix. You also have had, let me see, 8 children, and you've not provided for them. So the mothers of these children, and I'm sorry, I understand you lost one child. The mothers of these children have been solely providing, and then one of the mothers, you lost your child into the system because she was also using drugs.
Yes.
Sir, at what point do you realize that your addiction isn't just affecting you, it's affected your family, your community?
I haven't. It's hard out there when you get out, and then you hang out. People saying people come hang out with you, and I don't want them to hang out. I don't really need more friends out there. I need help, and I don't know how to go about it. And that treatment and stuff, and that's all I want is I can take care of my children. I'm proud to have my kids come over to my house for Christmas and stuff like that. If I have a house, I don't have a house now for my kids. Even come see me is kind of embarrassing. And I try to take care of my kids best I can. I give money when I can. I give money to my.
When you climb in bed with a woman and there's a potential baby and you did that 8 times, you think about the house then, not after you're addicted and the kids are out there without a dad.
Yeah.
You're a little bit late to the story here, sir.
Yeah, I know.
And then you have a sibling that you lost through an accidental overdose. You've been using, probably you lost that job through poor attendance because of addiction, because you had a really good job. We tried to treat you, and you didn't want that. You didn't change your life in terms of hanging around the same old people. They come around, you're buddies with them, and you get the next high. You've been in front of a judge 19 times. I have 19 offenses. I've granted some things were dismissed, but you have, you know, assault. There's lots of charges here, sir. I can't, and most of them are drugs and drug-related things. We tried. The only one who didn't try is you. Sir, I am giving you, I could send you to prison, but what I'm going to do is give you 365 days jail, revoke probation unsuccessful, 73 days credit while you're in jail. You'll be seen by medical. You will be part of AA, NACA, whatever treatment programs we have. And I don't know in the jail if they have any trade school or education available, but you should complete CATS, any trade school they offer, any housing information. Do you even have a social security number or ID?
Yeah, I don't have an ID. I haven't had an ID in 10 years since I've been in California.
Well, where you tell the jail that before you leave, you need to have an ID that they can help with that, okay?
Yes.
Or social security, whatever they can do, okay?
Yes.
No regular release, no tether release, no trustee status. Sir, you said it yourself, you're too old for this, and we've got yet another count coming up. I don't know what I'll do with that, but this has to stop because it's jail or a body bag at this point, or a prison or a body bag. I don't see the middle road because it doesn't seem that you really want it. You want to talk fast. You want everybody to believe you, as they always have since you were probably a teenager. They just believe what you have to say. I don't believe it. I deal in evidence, and the evidence is you need a whole lot more help, and you're not willing to put in the time and give up your old friends and your old life because some part of you really enjoys it and you're just getting by. No more getting by. Let's get sober and live the life God gave you, because otherwise he's going to take it from you. I don't know what you're going to see to him or say to him when you see him. What are you going to say? I'm sorry I wasted my life? Have you ever thought about that?
No.
Every child is born to greatness. You still have an opportunity to achieve greatness if you want it.
I do want
Then prove it, sir. I deal in evidence.
I prove.
Right? And you don't even need to prove it to me. You need to prove it to yourself. You need to look in the mirror every day and say that you want to live and that you're worthy and that you're going to achieve something good. And every day just take a little step toward sobriety, toward being good, and toward uplifting your life. It's your life. If you want to throw it away, you can do that, but you won't do it under my watch. You have 42 days to appeal and to request top counsel.
You acknowledge your receipt of this form, sir? Do you have a form in your hand?
Yes.
That is your notice of your appellate rights. Do you acknowledge receipt?
Okay.
Have you received the forms?
Yes.
Thank you.
Thank you. That's all for the record.
Okie dokie, friends. So a little while ago in the chat, Eric, one of our resident Canadians, asked why people stand for the jury if it's supposed to be a jury of their peers, and wouldn't that assume equality? And there was some takes on that in the chat. Let me give you mine real quick. I think more than anything, it's a sign of respect, no different than if you were going out to dinner with some people and you arrived at the table before them and then they arrive and you stand to greet them. Most often, if I haven't seen my wife all day and she enters the same room that I'm in, I stand up to greet her. It's a sign of respect. More than that, even, if you consider it, these are people who are ripped out of their normal lives, and they're ripped out forcefully, to be honest, because if you don't respond to a jury summons, you're in trouble for it. They're forced to sift through all the evidence, stay impartial, and then decide whether or not somebody gets to keep their freedom. That's an incredibly heavy lift if you think about it, and I think showing some respect for the people that do it, not such a bad thing, whether they are your peers from your same community or not. It's a respect thing. That's what I think. Okay, friends, that having been said, it is the final hour now of TCF Live on the Super Friday, and it is time for our guilty pleasure. If you are new to the channel, this is going to be the best, worst courtroom you have ever seen. The blood red carpeting, the lighting that is ripped from the Soviet-era war rooms in the USSR. The wall of tears behind the judge. The faint echoes and cries of the dead and the undead from the background. A printer that never stops running. One microphone for the entire courtroom that is overly modulated. people dressing in their best shorts, hoodies, flannels, shouting at each other because, again, overly modulated microphones. Sometimes you can see the walls cry blood. They say that Appalachian justice is best served from a cold, dank basement, and therefore, ladies and gentlemen, let's celebrate that. I give you Dungeon Court.
You're not Joseph Doherty, so.
I am. I'm right here.
Okay, Joseph Doherty is case number 25682. Fines are paid. You were to get a drug and alcohol assessment. Have you done that?
Yeah.
Where did you go for that?
OVP with Catherine Dawson.
Okay. Do you have a report or anything from them?
She said that she was sending it to you guys.
I don't have anything.
I don't
Are
know.
you continuing to see her? Or?
I'm planning on it, yeah.
Okay, I need a report. Is Mrs. Mint here today?
I'm not saying you're young.
Okay. She's from OVP, and sometimes she's.
Yeah. She was the one who helped me get set up over there.
Okay. All right, well, at the next hearing, I need you to bring a report or make sure they get it in here.
Okay.
Are you working?
Yes.
What's your work schedule?
I'm I'm on every day but Tuesdays.
Your off days are Tuesdays?
Yes.
Okay, well, we have court on Mondays and Fridays, so.
I can work in when I need to.
Okay. I'm going to set you for July 27th. That's a Monday. So we're going to report in from ODP at that time.
Just at 9 again?
Yeah, 9 o'clock. All reviews are at 9.
Alrighty.
Okay.
Thank you, Judge.
July 27th.
Yes, sir.
Well, Cynthia Gannon, 25,547. She's at TPC. Got a report. Okay, it's a very good report, so good job.
Thank you.
You still have, with your community service, you just have your fines to pay.
Yes.
Are you making a payment today?
Yes.
How much are you gonna pay?
I'm gonna pay at least 50.
How much?
50.
50? Okay.
Yeah.
All right. Does it matter if it's Mondays or Fridays?
Fridays matter.
Fridays are better?
Yeah.
17th of July will be your next hearing. 9 o'clock. Let's see the clerk to make your payment.
All right, thank you.
Yeah. All right, John Guido, I think he's on teleconference, it's 25,944.
Yes, Your Honor.
Okay. Are you still at the counseling center?
No, I graduated their program.
I see you completed outpatient.
Yes, I am still going through, I cannot remember the name of it, here in Jackson for mental health. That's a different story. Not the drug counseling center. Just trying to get down the bottom of maybe ADHD or something with adults.
Okay. You did 4 days of community service since your last hearing. You got 1 more day to do, and you got to pay on your fines. So you have a payment today you're making.
Yeah, I took a training class last week, unpaid, so I'll make a payment next Friday, if that's okay.
Okay. I'll set your, give you a new review hearing date. You are working, right?
Yeah, don't worry right now.
Does it matter if it's Mondays or Fridays with your work?
If we need a video, it doesn't matter, you can do it anytime.
Okay, as long as you're making progress, I'll let you appear by teleconference.
That's fine.
Okay, so I'm gonna set you for July 17th, that's a Friday.
Okay, July 17th is a Friday, 9 AM?
Yes, sir.
All right.
Get your one-day community service done and keep making payments on your fines.
All right, thank you so much, I appreciate it.
You're welcome.
Thank you.
Jonathan Harr, 16926.
Yes, sir,
Mr. Harr is on teleconference. Okay, I don't see that you've done anything since your last hearing.
I put myself in the streets of Dallas the day after you let me out, and they're gonna work with me here to get that done. I'll let you know that I need to get it done, so.
Okay, so
I'm
you're,
trying to.
what treatment facility are you in? Oh, Shawnee, I see you.
Yeah.
All right, I recognize you, so I know where he is. All right, that's fine, we'll work with you. I want you to get clean and sober. We're just putting a stay on what you gotta do, though. It's still gonna be here, you're gonna have to work on it, so. Any time frame on his program that you can give me?
He's currently in 2.5, so he's pretty early in the program.
Okay.
And he can't work or anything yet, so community service is something we could definitely make work right now. Also, you guys want progress reports for him weekly?
It doesn't have to be weekly, but I'd like to have it at the next review hearing.
Okay, sounds good.
Okay, so I'm gonna set in for July 13th, and that's a Monday.
Okay, thank you.
July 13th, as long as he's in treatment and doing well, he can appear by teleconference.
Sounds good, thank you.
Thank you. Scott Heisel, 25-807-808. Okay, you were to do some counseling also, has that been happening?
It had been, but we separated since.
Okay. So what about the counseling? Where did you go?
Through PATH, in Chesapeake.
Are you still going there?
We haven't had one since. I haven't heard anything from her. She doesn't message on that close. I don't know.
Okay, well, I need a report from PATH, and I'd like for you, because I don't want to see this happen again with her or anybody else, so I want you to continue with PATH.
Okay.
And get me a report at your next hearing, and I'll set it for July 10th. So that's a Friday.
Okay.
July 10th, 9 o'clock, report from PATH, bring with you.
I can do that.
Okay, we'll see you again, 9 o'clock, July 10th. William Lane.
Yes, sir.
Is here 15-41-37, and he is at Bethesda.
That is correct.
It's a good report. Good job.
I want to apologize about not being able to finish my community service. I kind of ended up in a bad situation and lost transportation to finish it, so appreciate the opportunity to.
Your Honor, he did come speak to this.
Okay, well, we'll make that a part of his program, right?
Yes.
We'll start doing some of that, getting it done. Okay, July 10th will be your next hearing, 9 o'clock.
9 o'clock?
Yes, sir. You got a good start, keep it up.
All right, thank you.
Thank you.
You're welcome.
Brian Lively, Ashley Mays, James McClellan, Sean Miller, Alexis Smith, Jason Stapleton.
Brian Lively, TRC 25-21-28. Did the dip school, you still have community service?
Yep.
Your Honor, if I may, Mr. Lively was ordered on April 24th to be here on April 25th. He was not here and has not been here since then.
What do you say about that?
What was that for?
Community service.
Oh, I was supposed to come the day after, but I had to work. I've been working on Saturdays at our dealership.
Okay, I'm going to put you in custody then. Commanded into the hands of the sheriff at this time. I'll deal with you in report. Ashley Mays, 23,517. Okay, you've been making monthly payments. You have a payment today. How much are you paying?
20.
Okay. We're setting you for July 6th. July 6th at 9 o'clock. That's a Monday. See the clerk will make your payment. James McClellan. James McClellan.
Yes, sir.
On teleconference. 16/35/21, 18/11/68, 21/6/82. Also a Shawnee. How's he doing?
Good, how are you?
Good. So.
Did you say how is he doing?
Yes, I was waiting for you.
Yeah, he's doing really good. He's still in our 2.1 program and works full-time, makes it to all of his groups. He's compliant in all treatment requirements right now.
Okay. And at some point, well, maybe you can now since you're working. Can you make any payments on your fines?
Yeah, I can pay Tuesday when I get paid.
Okay, start making payments on your fines. I'll set you for July 6th also. So 1 month, we'll see you. July 6th, 9 o'clock, you've got fines, and I believe there's still community service you have. You can do it. You can do it. You can do it in Portsmouth at the municipal court down there since you're close.
All right, we usually do it at Cornerstone too. We didn't do it last month for whatever reason.
Okay, any place else you need to get approved by Mr. Cooper? Okay, July 6th is your next hearing.
All right, thank you.
Sean, you're up. Sean Miller. Yes. 24/7/39, 24/23/65. Okay, it's a good report, and it sounds like you're wanting to get involved in substance use treatment as a profession. So
Yes.
you're studying to do that, so that's good. Good job. Can you pay anything on your fines here?
Not today, but I get paid next week on Wednesday.
Okay.
I get paid every 2 weeks.
Start making progress on those.
Yes, sir.
Does it matter with your work schedule?
No,
what day of the week it is?
It don't matter.
I'm going to set you for July 13th. So write that down. July 13th, that's a Monday, 9 o'clock.
Thank you.
You're welcome. Keep working.
Yes, sir.
Thank you, Your Honor.
You're welcome. Alexis Smith, 193668. She is still at?
She was completed.
Okay. All right, well, Alexis Smith completed stepping stones, May the 8th, but she's not here today.
I have not heard from her today.
If you have a contact, you can let her know she's going to have a warrant in 7 days if she doesn't appear.
Absolutely.
She needs to get in here.
Thank you.
Your Honor, if I may, she was not community services.
Okay. All right, there'll be, if she doesn't get in here soon, she's going to have a warrant to deal with.
Thank you.
Thank you. Okay, Jason Stapleton is here today.
Yes, backing up what Lindsay just said in the chat, horrible audio is part of the charm here with Dungeon Court. Let's get back to it. About 10 more minutes left.
25, 525, 25, 17, 96. And you're,
I made a payment this morning. I came in to pay cash, but they said that I would have to wait till after court. I figured it's going to be busy, so I just paid it online, but I can give you a...
how much are you paying?
I paid $40.
You've already paid it?
Yes, you want to see it?
No, I'm gonna put it.
That's two.
Oh, congratulations. All right, July 6th will be your next hearing, 9 o'clock. Kirsten Shipman, 23,698. Orange County Recovery. Is compliant. And you got stuff going on common pleas too, right? So,
Yes, that's why I came in today, because I am being sentenced and I will go to jail to go to prison on Wednesday.
now,
And my next review hearing wasn't until Friday.
are you going star or prison?
I've got sentenced 48 months to out and 6 to start.
To start, okay. All right. Where's the baby going?
With my mom.
Well, what I'm gonna do, then I'll put you off. So it's gonna be 6 months?
And then I'll be in STAR after the 6 months.
Oh, you're going
Yeah, I have to go to
then
prison.
Star.
Yeah, I have to go to prison for 6 months, and then I can judicial out to STAR.
Okay. Well, we need to wait even longer. Let's see. I'll set your next hearing for June 7th, 2027. So I'm giving you a year off.
Thank you.
Okay, good luck. We'll see you in a year, June 7th. June 7th, 2027 is your next hearing, 9 o'clock. Jared Stover is here. Case numbers are 24,461, 25,501, 2619 and 20, and I've got a report from ROS. Okay, good report. The screens are all negative and everything you say is positive, so. All right, so let's see, what else have we got to work on? Funds on the first one are paid. Still have some funds and costs to pay. Do you have a payment you're making today?
I paid 100 yesterday.
Okay. Mondays or Fridays for your hearings?
Fridays.
Fridays,
Please. Yes.
July 17th. 9 o'clock. Okay, good job.
Thank you, Your Honor.
You're welcome. Jason Taylor. Jason Taylor's cases are 17, 22, 66, 25, 24. Community service done, working on funds, so you have a payment.
Yeah, I'm gonna make a $40 payment online when I leave here.
Okay. Okay, we're gonna check and make sure you do.
Okay.
July 6th will be your next hearing, 9 o'clock.
Is that a Monday?
It's a Monday.
Okay, I just said that works better for me. I'm on.
July 6th is a Monday.
Thank you.
You're welcome. Mark Wells is here. 17, 1273, 20, 2014. You're paying off your funds. Do you have a payment?
Got 10.
Okay. I'm going to set you for July 2nd. Because the 3rd is a holiday, so that'll be a Thursday, July 2nd at 9 o'clock.
All right, thank you.
You're welcome. Go see the clerk. Shania Westmoreland. Not here. Case number is 18228, still has community service to do. Hasn't appeared, so it'll be a warrant. Failure to appear. Okay, that finishes the reviews. We're going to start arraignments now.
Alrighty, friends, I don't think there's a better place to leave dungeon court than somebody getting a warrant for not showing up to dungeon court. I hope you all had fun today and this week. I know I did, so thank you for giving me your time. Thank you for the generosity you all have shown throughout the week, and especially today, because there was a lot of generosity today, to be sure. I've said it before and I'll say it again. This is one of the best things I've ever done. So thank you all for sharing it with me. I will be back with you on Monday, 9 a.m. Eastern, 6 a.m. Pacific. Join me a half an hour early if you're a channel member. Join me for that pre-show. And look forward to seeing you all soon. Have yourselves a great weekend. Take care. God bless.